Which one? Which one?
That advertisement in a paper, a Dibrugarh case.
Paper publication, yes.
Yes, is the date of appearance of the parties. Your lordship passed that on, it should come up on appearance date is 28th of July, no? July. Now that has not been, that has been written as next date is 28/7. So therefore, appearance of the parties will have to be given.
On 18.
On 28/7.
No. When do you want?
On 18th.
Okay.
Obliged.
Please, Your Lordship. The concern on the other side, I take to mention item number 40.
40.
40. Today we have some difficulties. Lordship, let the matter be adjourned for today.
I am for the respondent, Lordship. Can you fix a date? If possible, Lordship, on 23rd or 24th of July.
Okay. As agreed by learned advocates of both the parties, SSL is the matter on. On
23rd or 24th?
If possible, let it be on 25th.
Okay, on 25th.
Okay.
In time is there, Lordship, in time report.
Pardon?
In time is there.
Okay. Interim order passed earlier shall continue.
Lordship.
Yes. May I please, my lord, I beg to mention item number 38, my lord. Prepare for withdrawal, my lord. It is stray matter. Stray may be vacated, my lord.
Item number?
38, my lord.
You want to withdraw the matter?
Yes, my lord. As per instruction of the petitioner, my lord.
Okay. Heard, Mr.
A. Dutta, my lord.
A. Dotto, learned counsel for the petitioner. Mr. Dotto submits that he has the instruction to withdraw this petition. And he also submits that the interim order may be vacated. Taking note of the submission of learned counsel for the petitioner. This as per petition number so and so stands disposed of on withdrawal. Interim order passed earlier stands vacated.
Highly obliged.
May I please, Your Lordship, my lord, I beg to mention for listing of a CRPIO, my lord. In this case, my lord, the execution of decree has been stayed by this honorable court, my lord. I am for the respondent, my lord. Matter will be taken on next Wednesday, my lord. For last 2 years, my lord, decree has been stayed, my lord.
18/6. 18. On 18 June.
Wednesday.
Okay. Yes.
May it please your lordship. Lordship, with the consent of other side, I beg to mention item number 14, lordship. Lordship, the matter may be adjourned for the day 1/4.
The prayer being made by Mr.
A. Singh, lordship, for the
Learned counsel for the appellant.
appellant, lordship.
You inform the other side
Yes, lordship.
Waiting for the
with consent from the other side plus for listing the matter after.
Last week of June, lordship.
After vacation. No? Many cases.
Last week of June may not be possible.
After vacation.
After vacation.
Obliged, lordship.
Take a date from him.
May it please, Your Lordship. So I beg to mention item number 12. So here we were supposed to submit a report by the DEO, my lord, as per your lordship direction. So it requires further 2 weeks time, my lord. I've informed the counsel for the petitioner.
You inform the petitioner.
Yes, I have informed the petitioner. Is there?
Any objection?
No.
No. Mr. Kosik, learned standing counsel for the elementary education department. With consent from the other side, press for listening the matter after 2 weeks.
After 2 weeks.
Fair allowed, resolution is the matter as part heard.
Grateful.
May it please your lordship. I beg to mention item number 1 of the daily list, your lordship. My learned senior is out of station, your lordship. Your lordship, if your lordship allows, the matter may be adjourned for today, your lordship. And it may come up
On the
18
request made by Mr.
J.K. Roy on behalf of R. Sharma.
G.K. Roy, learned
On behalf of
counsel
R. Sharma.
appearing on behalf of Mr. R. Sharma. The matter stands adjourned for the day.
It may be fixed on 18th if your lordship allows.
Raise table fix.
May it please your lordship. Item number 16, the other side is here. No, sir, there is a top-up compromise and they have to get the matter listed in local law. So if it doesn't have to
Item
be
number 16.
60.
16, it may come after 2 weeks, or if it doesn't
Is
get
it
settled,
admitted or not admitted?
not admitted.
Then
Both the parties are here also. We are trying.
unless the matter is admitted, how can I direct the registry to list the matter before?
There is a talk of lordship here. They have already placed the list before the local.
No, that's all right.
Yes, otherwise I thought If it
First,
is,
I have to admit the matter only, and I can exercise my jurisdiction.
Lord, it will come next week in that case. It will
Pardon?
come next week, Lord.
Next week.
Yes, Lord. Don't have-
No, not today. We will admit the matter.
Yes, sir, that can also be done. Yeah.
And thereafter, we will direct the SC to list the matter before look at the law.
Okay. What again? Public.
May please, your lordship. Lordship, I beg to mention item number 24, lordship.
24.
Yes, lordship. Miss Anne Agarwal has some personal difficulties in.
On the pair being made by Mr.
M. Das.
Learned Counsel for the appellant, raises a list the matter. When?
Next,
Sir?
next week, lordship.
Next
After-
week, Lord.
Next week. Next week.
My lordship, lordship, mention item 11, lordship.
11.
Yes, lordship. Conducting counsel, Mr. Ayar Fuya's mother-in-law expired recently, lordship, so he's in bereavement, lordship. Only matter be taken after a week, lordship.
After a week. On the request made by Mr.
NZ Chaudhary,
N.
Z Chaudhary.
NZ Chaudhary, Learned Counsel appearing on behalf of Mr. A.R. Bhuiya, Learned Conducting Counsel for the petition. You inform the other side
Yes, lordship.
with consent from the other side. Raises a list the matter after a week.
Yes, lordship. Obliged. Items from daily list for motion, item number 2.
May I plead the lordship? My lord, the petitioner is the wife, my lord. So initially the petitioner has filed a petition under section 12 of the DV Act against the respondent in Bishwanath. She is from Bishwanath, my lord. And the husband is from Tinsukia. So subsequently, the husband has filed a divorce petition in Tinsukia, my lord. And petitioner, she is the only child of her parents, my lord, living in Bishwanath, my lord. So it is not possible for her to go to Bishwanath and conduct the case there. Therefore, my lord, she is praying for transfer of the case to Bishwanath. Even the other case, DV case, my lord, that is also proceeding in Bishwanath, where the husband is also appearing, my lord. So at this stage, notice may be issued, my lord. The petitioner has received the notice at page 30, my lord. So the next date is,
No. Is it necessary for the petitioner to appear before the learned court at Tinsukia on each and every date?
yes, my lord, because it is a divorce case, my lord, she has to appear.
Hmm?
She has to appear, my lord.
No, she can appear through her advocate.
But my lord, it is fixed for appearance on 26/2025. Now also she has to go. Otherwise, my lord, the husband is coming to Bishwanath for the DV case, my lord, who is at page 14, my lord.
Hmm.
So for husband, my lord, it is easier to come here, my lord. But petitioner being the only child of her old ailing parents, my lord, it is not possible for her to go there. Financially also she is weak, my lord. Her father is doing some clerical works outside a bank, my lord. He is not even a bank employee, my lord. Petitioner is unemployed, my lord.
Art Mr. B.P. Bora, Learned Counsel for the petitioner. This petition under section 24, read with section 151 of the Code of Civil Procedure is referred by the petitioner for transferring PS within bracket M 46 of 2025 under section 13(1) the bracket Roman 1A of the Hindu Marriage Act. Pending before the Court of Learned District Judge Tinsukia to the Court of Learned District Judge Vishwanath Reddy. Mr. Bora, Learned Counsel for the petitioner submits that the husband of the petitioner resides at Tinsukia, wherein he has instituted one proceeding, one divorce proceeding, being PS within bracket M 46 of 2025, and that the petitioner is financially weak and is the only child of her parents, old and ailing parents, and she is not in a position to contest the aforementioned proceeding before the Court of Learned District Judge at Tinsukia. And further, Mr. Bora submits that one domestic violence case is also pending in the court at Vishwanath Ceremony between the same parties. And the respondent herein is appearing in the aforementioned proceeding. And as such, Mr. Bora submits that title suit number so and so may be transferred to the Court of Learned District Judge at Vishwanath Ceremony. The submission of Mr. Bora needs further consideration at this instance. Notice be issued to the respondent, returnable in 4 weeks. Study taken by registered post with AD and also by user process within a week from today. Further, considering the submission of Mr. Bora, learned counsel for the petitioner, further proceeding pending before the court of further proceeding of PS number so and so pending before the Court of Learned District Judge in yes, then state will return the list of the points.
Deeply obliged.
Item number 3,
May I please, Your Lordship.
Yes,
Lordship, petitioner before Your Lordship at the judgment debtor, they file a petition under section 47, read with 151 of the CPC. Lordship, kindly have a look at the petition filed by the petitioner before the executing court. That is at page Lordship 67.
yes.
Lord, may I read? And the JD of the above noted case back to submit that the petition filed by the decree holder for execution of the decree is not maintainable in law. That when the possession of the suit property has been determined by the competent revenue court, the civil court shall not evict a person from the suit land without a decree. When the revenue court decided the possession of the defendant, judgment debtor, a civil court cannot change the matter in above execution of a decree. Lordship, original suit is for a declaration of right title and interest and confirmation of possession. But now at the execution stage, it is likely to recovery of first possession. We are in possession of the land. And also Lordship, Revenue Court passed order in favor of us. And Lordship, my submission executive court cannot go beyond decree. Since it is a decree for declaration of right title, and
You tell me what is the scope under section 47 of CPC, read with section 151 CPC for the learned trial court? Can the learned trial or no, learned executing court go behind the decree?
Lordship,
You have preferred an appeal and therefore you have not pursued it. It was
Lordship, it
dismissed.
is it was appeal was
Dismissed.
dismissed.
And you have also not preferred any revision petition,
Lordship,
but you have filed on petition under section 47 of the CPC.
Lordship. Before the
So what
executing
is the scope? Whether the learned trial court under section 47 of CPC can go behind the decree?
No, that is not Lordship.
Tell me.
But Lordship, decree
And how
decree is about for confirmation of possession, Lordship. but not for recovery of possession. That's why our objection was.
Section 47 is not a substitute for an appeal or review petition.
That is true.
The
but,
learned trial court, executing court, discussing a decision of Supreme Court in Vasudev Dhanjibhai Modi and Modi versus Razabhai Abdul Rahman and others, reported in 1971, 1 as SCR 66. There's a dismiss the petition.
Lordship.
So you tell me how the executing court has committed any illegality or impropriety
Lordship,
to
illegality,
exercise the revisional jurisdiction by this court.
illegality, Lordship, it is a decree of declaration of right title and interest and confirmation of possession. But now, Lordship, it was they are supposed to take recovery of possession. That is illegal, Lordship. That is not permissive. So that the issue can be decided by order of section 47, Lordship.
Let us see the decree,
Lordship.
that page number.
Lordship. Lordship, it is at Annexure 1, Lordship, page 25.
25.
25, 26.
Whether you have enclosed the plain here,
Lordship,
plain.
Lordship, plain was not annexed. Not annexed, Lordship. Lordship, I may be allowed to file additional affidavit for if required, Lordship. Plain,
Here the pair is made for confirmation of possession.
Lordship.
It means
Lordship,
that the
your Lordship,
possession
kindly
is
come
with
to
the
page
plaintiff.
26. Page 26.
It means that the possession is with the plaintiff.
Lordship, but in this, where we are in possession by the present execution proceeding, Lordship, that does dispossessing our land, Lordship. That is our objection. Whatever they are in possession in land, they are in possession, we have no objection. But land we are in possession, and that is confirmed by the revenue code, that is to be likely to be disturbed by
No.
executing court.
Here it is stated that the trial court has declared the right equity as illegal and also directed to cancel the mutation.
Lordship.
What is the scope for interference? You tell me.
Lordship, regarding the recovery of possession, there is every scope. But confirmation of possession, there is no scope, Lordship. But we are only to that extent.
You have the copy of the plain tweet.
Lordship, it is with not with me, but I can collect, Lordship. That I can also file, Lordship. By filing an additional affidavit, Lordship, allow me to sometime.
Heard Mr. L.R. Mazumdar, learned counsel for the petitioner. Mr. Mazumdar submits that he has not enclosed the plain of title suit number 83 of 1996 along with his revision petition. And he tries for granting him some time to bring on record the plain of the title suit number so and so. By filing an additional affidavit, there is accordingly allowed. This is the list of matter on next use for Wednesday.
On 18 June.
Of like,
Item number 4.
Lordship, matter relates to that limitation issue, Lordship, that is to file within 6 months from the date of accident, Lordship. The accident, it took place, Lordship, in 2023. New Act came into force from 1/4, Lordship, 1/4/22.
But whether any accident information report was furnished by police to the court?
I don't have any instruction in that regard.
You obtain instruction and obtain a copy if it was furnished to the tribunal.
Also, if the honorable court, Lordship, passes order to the police, that is, Lordship, helpful. Otherwise,
No, police is not a party in this proceeding. How can I direct it?
Lordship, otherwise they do not give any proper response, Lordship. In earlier cases also, Lordship, we tried, but they did not give any instruction, Lordship.
Okay, after some time, we will include the state of Assam as party in this petition. Then we will direct the additional PP to produce a copy of the accident information report before this court. Wait for some time.
Yes, Lordship.
Item 5.
Wait, Your Lordship. Here in this case, Lordship, the opposite parties file an title suit for declaration of specific performance of contract and consequential relief. Subsequently, Lordship, I also filed a title suit, and my prayer was for right title interest on the suit land, injunction, and recovery of khas possession. And thereafter, they filed one application under section 10 of CPC, Lordship, saying that it is there is a residual, so that petition our title suit may be stayed. And accordingly, stay order was passed. Lordship, may kindly see the our objection file in that said petition, page 48.
Page number?
48, annexure 5.
Yes.
Here, Lordship will kindly flip page 49, relevant portion. First, we have quoted the paragraph of their title suit that your Lordship will find, declaring that the actions of the plaintiff of the present suit, defendant of old title suit number so and so, of non-execution of the registered sale deed of the suit land in favor of the defendants of the present suit, is illegal, void, and inappropriate in law, inoperative in law. Number 2, directing the plaintiff of the present, the defendant old in title suit number 3423 to execute the registered sale deed of the scheduled property in favor of the defendants of the present suit. Number 3, of confirmation of the possession of the defendants of the present suit
The plaintiff of old title suit 3423 over the suit land. Number 4, cost of the suit may be declared in favor of the defendant of the present suit.
Mr. Ahmed,
Lordship.
you come to paragraph number 17 of the impugned order.
Yes, Lordship. Yes, that I have seen, Lordship.
So what wrong with this order?
No, here in my title suit, Lordship, there is a prayer for recovery of khas possession. Even if I, Lordship, win in the other title suit filed by them, Lordship, then again I have to wait for another more time for that disposal of that case, Lordship. And if it goes together, there no harm will be caused to the other side also, and it will save the judicial time also, Lordship. And in fact, if your Lordship turn to page 51, in my objection, paragraph 7 and 8, I have given that the issues in both the cases, Lordship.
Page number?
51. In their case, Lordship, that recovery cannot be ordered, Lordship. That is the difficulty. Page 51.
No. In paragraph number 17,
17.
the trial court has observed
Lordship.
that as such the opposite party, by adducing evidence in PS number 34 of 2023,
Lordship.
filed by the petitioner, can prove the fact that he was ready to perform his part of agreement, for which he is entitled to a degree for khas position,
Lordship.
and the agreement for sale to be cancelled. Both the parties, by adducing their respective evidence, can counter the allegation of the other side.
Lordship. That part is, I'm not
Considering
disputing.
the matter and in entirety, and to avoid multiplicity of the proceeding, the prayer for stay of PS number 31 of 2024 is allowed.
The only difficulty is the possession is with them. So if my title suit is stayed, I will not get the possession, Lord.
No. Here clearly observe that if he is entitled to a degree for khas position.
No, here as such the opposite party side by adducing evidence in title suit number 3423 filed by the petitioners can be proved the fact that he is ready to perform his part of agreement for which he is entitled to a degree of khas position and agreement for sale to be cancelled. Both parties by adducing their respective evidence can counter the allegations of other side. So here, Lordship, my case was that he was not after paying 10,000, he was not willing to perform the other part, Lordship. Therefore, I have filed for cancellation of that, Lordship. Only by paying 10,000, he has took possession of the land. He and the other payment he is not paying, Lordship, and he has violated the terms and conditions of that
That
agreement.
will be decided by the trial court.
But ultimately, the possession will remain with him, Lordship. That is the difficulty. And that part can be decided only in my case, Lordship, regarding possession.
So it appears that no illegality has been committed by the trial court in staying the proceeding.
Because, Lordship, just I am relying on one judgment of Honorable Apex that when that has to be applied, just for your Lordship. Yeah. Sorry, paragraph 10, Lordship. 8, paragraph 8. Paragraph 8, I am relying on 7 and 8. Here, in 7, it is that regarding section 10, 8. The object underlying section 10 is to prevent courts of concurrent jurisdiction from simultaneously trying two parallel suits in respect of the same matter in issue. The object underlying section 10 is to avoid two parallel trials on the same issue by two courts and to avoid recording of conflicting findings on issue which are directly and substantially in issue in previously instituted suit. The language of section 10 suggests that it is referable to a suit instituted in the civil code and it cannot apply to proceedings of other nature instituted under any other institute. The object of section 10 is to prevent courts on concurrent jurisdiction from simultaneously trying two parallel suits between the same parties in respect of the same matter in issue. The fundamental test to attract section 10 is that the parties whether on final decision being reached in the previous suit, such decision would operate as res judicata in the subsequent suit. Section 10 applies only in cases where the whole of the subject matter in both the suit is identical.
So is there any dispute that the subject matter in PS number 34/2023 and 31/2023
that part I am not,
are not identical?
That part I am not disputing, Lordship.
Then-
The only
then-
thing is that regarding that prayer. That prayer, that
How
regarding
this
recovery
the
of
decision will help you?
that line, Lordship, may kindly see. The fourth line from bottom, the fundamental test to attract section 10 is whether on final decision being reached in the previous suit, such decision would operate as res judicata in the subsequent suit. So there are no conflict between those two pairs, Lordship.
No, the trial court has not dismissed your suit. It is only state.
State, that is what.
Then there is categorical observation that the dispute can be adjudicated in the title suit number 34 of 2023.
Lordship. Because Lordship, he violated the terms and conditions, and therefore the petitioner is also not willing to fulfill that agreement, Lordship. That is the dispute between the two. And now in that situation, Lordship, when he violated the terms and conditions of that contract,
No, that will be decided by the trial court.
yes, that will be decided only for that purpose, Lordship, that possession. Because in his case, that possession will not be decided. And his Lordship is aware that possession is 9 out of 10 points.
Subject matter of both the suits are same.
Say that is same, but
Identical.
prayer is different, Lordship. And issues, Lordship, that your Lordship will find at page 51, paragraph 7 and 8 of my objection, Lordship.
There is no infirmity in the or illegality in the order. We are dismissing the petition, but I am granting you liberty. You can withdraw it also. Whatever option you can avail, you can avail.
Lordship will fix it next week, Lord. Next week, Lordship.
No, not next week.
In that case, I will be allowed to withdraw, Lord.
Pardon?
Withdraw, Lord.
You want to withdraw? For Mr. Ahmed, learned counsel for the petitioner. Mr. Ahmed step, he may be permitted to withdraw this civil revision. Taking note of the submission of Mr. Ahmed, learned counsel for the petitioner. This sheer distance disposal on withdraw.
Standing for.
All right.
Will you represent the state of Assam? You.
I was told, my lord, that prosecution is required to present before.
Not prosecution, exactly. It may be government advocate of
Oh, my
state
lord.
of Assam.
But that information I don't have, my lord.
Mr. Gogo is available.
My lord, maybe I'll see.
Can you inform him?
I inform, my lord. I inform the.
Okay,
Mr. Nasta.
Item 6.
Wait, please, my lord. And I'm preferring this present petition on being aggrieved by the order dated 15/3/2024, passed by the learned Civil Judge Junior Division, Kibohagor, my lord, in a missed case filed in the title execution case. The facts of the case is that, my lord, the respondent herein, as plaintiff, has preferred a title suit, my lord, wherein I was there as a defendant there. I have appeared, filed my written statement, and a counterclaim was also filed, my lord. After adjudication of the matter, my lord, the decree was passed in my favor. But when it went for execution, my lord, of the case after filing of the execution case by me, there was the Nazir found some discrepancy as regards to the schedule of the property which was mentioned in the suit, my lord, in the counterclaim, my lord. Accordingly, my lord, an application was filed, which my lord will find at page number 12. My lord has it.
Yes,
This application was filed for amendment of the, my lord, the schedule under order 6 rule 17 read with section 151, 152 and 153 of the CPC. But my lord, unfortunately, this application was filed in the execution case, my lord, not in the title suit. This ought to have been filed in the title suit, my lord, with my limited understanding. And accordingly, my lord, this petition was disposed of. My lord will find the impugned order at page number 19, my lord. 15/3/2024. And my lord, the observations as regarding to maintainability of this particular application, my lord will find at page number 19B. This is a type copy, my lord. The last paragraph, my lord.
yes.
Starts for. So, my lord, I have a very limited prayer before this honorable court now. I pray for that I may be allowed to file an application in the title suit, my lord. That is my only prayer, my lord.
No, the title suit has already been disposed of.
It has been disposed of, my lord. I'll try my luck.
Where
filing
is
an
the
amendment,
scope now?
my lord, I'll file an amendment, my lord, in the or an appropriate application before the trial court, my lord.
Is there any
Because
provision in the CRPC now?
as such, I'll have to file an application for amendment. No, as in, my lord, this amendment order 6 says that it has to be filed during the course of the, my lord, the pendency of the trial, my lord.
Then
that is my difficulty, my lord. I'll explore well, I'll file an application under section 151. As such, this is not maintainable, my lord.
come prepared. We'll fix it on next Wednesday.
Wednesday, my lord.
What provision we can consider your prayer?
I'll be filing there.
Or Mr. R. Hansel or Mr. Hansel, some extent it may be granted sometime to address this court about the appropriate provision under which the petition or amendment of the schedule of the title suit number 78 of 2008
My lord.
can be filed. It is accordingly allowed with the matter on Wednesday.
Pleasure, my lord.
Mr. Gogoi, in this proceeding, we will implement the state of Assam as respondent so as to enable this court to obtain a copy of the accident information report submitted by police before the learned member, Motor Accident Claim Tribunal, Nagaon.
We are not aware about this matter, Lordship, as because of our name also not shown in cause list.
No, today we implead you.
Lordship.
Heard Mr. A.J. Soikia, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or other ways of the order dated 3/7/2024 passed by the learned member, Motor Accident Claim Tribunal, Nagaon, in this case number 78 of 2023, filed by the claimant. It's the opposite party. After hearing learned counsel for the petitioner and also considering the facts and circumstances on the record, this court deemed it appropriate to implead the state of Assam as respondent number 4 in this proceeding. Accordingly, it is provided that the state of Assam be arrayed as respondent number 4 in this proceeding. So issue notice to the newly impleaded respondent. And also, Whether notice was issued earlier,
No,
also issue notice to the respondent number 1 and 3. However, no formal notice is required to be issued since Mr. Gogoi, learned government advocate, entered appearance received notice. However, extra requisite copy of the petition be furnished to Mr. Gogoi during the course of the day. Recessal also reflect the name of Mr. Gogoi in the call list. Further, taking note of the facts and circumstances on the record, Mr. Gogoi, learned government advocate, is directed to obtain instruction as to whether any accident information report was filed by the investigating officer of what is the PS case number
Lordship, Juria PS case number 263/23,
of Judia PS case number 263 of
23, Lordship,
23
under section 279 304A IPC.
under section 304
279 204A
79 30
4A.
304A IPC. Place the matter after 4 weeks.
Lords. Our name should be shown as in cause list as
already
Jia,
correct.
as Jia, Lordship.
You furnish a copy.
Lordship.
Item 7.
May I please your lordship? Lordship, my senior is on legs in court number 5. Kindly pass over the matter for time being.
Item 8.
May it please your lordship. But I am the plaintiff. And the defendant number 2 died, but I filed an application for substitution and along with a petition for condonation of delay of 52 days. That was rejected, and against that I am before your lordship. Your lordship, delay is 52 days. And as per the recent, your lordship aware as per the recent judgment, considering the article 120 and 121 of the Limitation Act, it has been held that period is 150 days. My petition has been rejected on the ground that I have not given details of the illness. At page 26, the operative point. Paragraph 9, madam. Plaintiff himself admitted that he was aware of death of defendant number 2 as he had attended the funeral of defendant number 2, and therefore there was no requirement for the plaintiff to be informed through court by the other defendants. I also do not find the ground given to be tenable as no details about what kind of illness the plaintiff was suffering was given. There is considerable delay in filing the petition, and considering the plaintiff was already aware of the death of defendant number 1, I deem it proper to reject all the grounds given by the plaintiff for the delay, and accordingly the delay is not condoned and the petition is rejected.
So why you could not file the petition?
My lord,
within
I
the
was
stipulated
in, my
period?
lord, my lord, I was in, my lord, page 15, my lord. Paragraph 2, that the plaintiff is now
Paragraph number
paragraph 2, my lord.
2.
My lord. That the plaintiff is now 65 years
The
old.
question is that you have not enclosed any document to show that you are suffering from any illness.
My lord, lordship will consider, my lord, it's a substitution petition, my lord.
Maybe.
Substitution petition, my lord.
Maybe. There also you have to explain the delay.
My lord, it is.
You have to show the relevant
it is the
document
poor- my lord,
in support of your
my lord,
contention.
lordship will consider, my lord, it's a poor drafting, my lord.
Pardon?
Right. Poor drafting of the petition, my lord. So for that, my lord, lordship, I may not be penalized, my lord. But because, my lord, this other side is not going to prejudice.
No, that is not the requirement of law. Requirement of law is that you have to explain the delay.
Delay, my lord. Or the recent judgment.
You see,
Well,
you come to paragraph number 10 of the impugn order. The trial court has observed that I do not find the ground given to be tenable has no details about what kind of illness the plaintiff was suffering.
The learned court was very rigid, my lord. So in substitution, lordship, numerous decision. It was the approach should be liberal. Numerous decision. I can place it, my lord. Let's do.
Place it, all right.
My lord, next week, my lord.
Next week.
Next.
It is not available with you now.
Now it is not available.
Not available.
Next.
Third is the KKT, Learned Counsel for the petitioner. Mr. Day submits that he may be granted some time to produce some of the decision of Honorable Supreme Court in respect of condonation of delay in filing the substitution petition. Where is accordingly allowed basis and
Can it be in the after the vacation? I shall take some instruction.
When?
After the vacation.
After the
vacation.
After the vacation.
Item 9.
My lord, the execution proceeding for recovery of rupees, decretal amount of rupees 2 lakhs, that was dismissed for default, my lord. And prior to that, this honorable court has stayed the execution, stayed the decree, my lord, in a second appeal. In fact, that was not communicated properly. And my lord, it was dismissed for default. Impugn order is at page 15, my lord.
Page
15. Married, my lord. Today is fixed for anno. Decree holder has filed Hazira but could not be found on repeated calls. Peruse the case record. Upon perusal of the case record, it appears that this case was instituted in the year 2021. In spite of repeated directions, decree holder has not taken step as per order dated so and so, so and so, so. Hence, on the basis of our discussion, it appears that the decree holder is not willing to proceed with the instant case, and thus this case is dismissed for default. Now, my lord, at page 9, the order starts from page 10, my lord. Had so and so for this one. Since the connected regular appeal, second appeal is admitted for hearing the judgment and decree dated so and so passed by the learned civil judge so and so shall remain state subject to deposit of rupees so and so. The intellectual application is state disposed of, my lord. So, my lord, it was state, and the learned counsel was informed regarding that. But in spite of that, she going on to file Hazira, and as a result of this, my lord, it was dismissed for default.
No, whether this order of this court was communicated to the
No, not communicated. As per record, it was not communicated.
not communicated.
Not communicated. And moreover, the case was not liable to be dismissed for default. It would be as a file, my lord.
Pardon?
My lord, the case may be filed, my lord, not as a dismissed for default. My lord, in the execution proceeding, there is no provision to dismiss for default, my lord.
Third, Mr. Saho, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 23rd/7/2024 passed by the learned civil judge junior division number 2 Moregaon in money execution case number 1 of 2024 arising out of money suit number 15 of 2014 under order 21 rule 11(2) of the CPC. Mr. Sahu, learned counsel for the petitioner, submits that the money execution case number 1 of 2021 was dismissed by the learned civil judge junior division number 2 by order dated 23rd/7/2024 on the ground that on the date fixed and also on the date fixed by the learned civil judge junior division number 2 Moregaon, the petitioner herein remain absent in the court and he is not taking his state as per order dated 6/3/2024 and 25/4/2024 and 11/6/2024. But Mr. Sahu pointed out that against the judgment and decree of the learned civil judge junior division number 2 Moregaon, the petitioner hearing has preferred one regular first appeal before the court of
Milord,
civil judge senior division
senior division.
Moregaon, and the same also came to be dismissed on when it was dismissed. You have not mentioned in the petition.
Milord,
And thereafter
8/7/23.
8/7/23.
18/7/23. It was dismissed by the
2023
Milord.
in title appeal number.
Entitled
The
appeal
money-
money appeal
money
number
appeal number?
1/2020.
Pardon?
1/2020.
1/2020. And thereafter the petitioner hearing had preferred one second appeal.
No, Milord, I have not preferred.
Who preferred?
The respondent preferred. I am the decree holder, Milord.
Okay. Thereafter, the respondent hearing had preferred one regular second appeal, being RSA number 188 of 2023, wherein this court by order dated 10/11/2023 has stated the further proceeding.
I restate the decree, in fact, Milord.
Yes, is that the judgment and decree dated 18/7/2023 passed by the learned civil judge Moregaon in MA number 1 of 2020. But the aforementioned order was not communicated to the council or the petitioner in money execution case number 1 of 2021. 1 of 2020. And as such, the interim order dated 23rd/7/2024 is illegal and arbitrary, and therefore it is contained outside the site. Having heard the submission of Mr. Sahu, learned counsel for the petitioner, I carefully went to the petition and the documents place of record and also carried the interim order dated 23rd/7/2022 and also the order dated 11/10/2023 passed by this court in IA Civil 3105 of 2023 in RSA number 188 of 2023. It appears that by the order dated 11/2023, this court has stayed the judgment and decree dated 18/7/2023, passed by the learned civil judge Moregaon in MA number 1 of 2020. And as such, the learned civil judge senior division number 2 Moregaon would not to have proceeded with the money execution case for 1 of 2021. And in that view of the matter, the impugned order dated 23rd/7/2024 is illegal and arbitrary and therefore the same is set aside and passed. In terms of this, CRPIO stands disposed of this motion is itself.
Item number 10.
Lordship may take it up after some time, seniors on legs.
You have a caveat.
Caveat, Your Lordship. Decree holder. This is from an execution.
That is that only notice will go.
No, Lordship. This case is regarding history, Lordship. Since 1977, it is going on.
Stay.
No, Lordship. Lordship. Case is, suit is. Now execution proceedings has been filed and they have filed a petition under section 47, defendant number 2.
No, that was dismissed.
It has been dismissed. So they have filed this petition. Now I am appearing for the decree holders. So notice others is the defendant number 1, the pro forma respondent.
You are for defendant number.
I am for the plaintiff decree holders.
Decree holder.
Decree holder.
Let us in your come.
Number 41.
Your Lordship, finally the matter may be passed.
For the day.
Lordship. Witness will not be available. Then after this week, next week.
Next week.
Next week, after 20.
Is B. Hazarika, learned counsel to the respondent with consent from the other side, plus for adjournment of the matter for the day. Here is since allowed. Rest will is the matter after vacation. After vacation.
Deeply obliged.
Item 42.
May please, Your Lordship. Lordship, this is a petition under Article 227, whereby I am challenging 2 orders, my lord. My lord, Annexure 5 and Annexure 10, my lord. My lord, what has happened? I, as a petitioner, being the plaintiff, had filed a suit for recovery of possession, declaration of right title in interest, and for cancellation of a particular sale deed, my lord. Being a fraudulent form of sale deed. The suit was dismissed, my lord. So I filed the first appeal. During the pendency of the first appeal, my lord, I preferred one petition under Order 41, Rule 27, for adducing of additional evidence, my lord.
That was allowed.
That was partly allowed, my lord. What happened, my lord? There, actually, I had requested for FSL examination, my lord. Now, while deciding
No, that was allowed.
FSL was not allowed, my lord, because the mother had in the meantime expired, my lord.
Okay.
As such, no FSL
Advocate
could be done.
signatures are available.
But while disposing of the petition, my lord, certain finding came to be recorded by the learned trial court, by the learned first appellate court, that the sale deed, of which I have sought the cancellation, consists of the thumb impression. But, my lord, in reality, it consists of an alleged signature of the mother, of the petitioner, which we are challenging, my lord. We are telling it is a fraudulent false signature and a fraudulent piece of document. As such, we have been taking that stand right from the trial court. Now, what has happened as regards that finding, my lord, after when the petition was pending for perusal, my lord, and the judgment, before the delivery of the judgment, I could lay hands upon another document which was given by the State Bank of India, stating that the petitioner is illiterate and as such she cannot
no signature is present in the bank account of the petitioner's mother. Now that piece of document is very crucial, my lord, as per my stand, which pertains to the sale deed, my lord.
But appellate court observed that State Bank of India is not in a position to give such a finding.
Agreed, my lord. That is not the authority to tell whether I am illiterate or illiterate. But that this document, if it is allowed in the evidence, my lord, then it gives a strong probability, my lord, like probability that the petitioner is illiterate and cannot affix her signature anywhere. Because in the pension papers, everything, her thumb impression is there, not her signature. No signatures are there. And on account of the death of the mother of the petitioner, we are not in a position to send the documents for FSL. That has rightly been held, my lord. But that the second document, that is at page, my lord, 89, my lord, that has been produced. We could lay our hands during the pendency of the Order 41, Rule 27 petition, my lord. So naturally, when that petition was pending for judgment, my lord, for orders, we could not have produced this document. After that, we could produce. So we filed a review petition, my lord. Now the learned First Appellate Court came to a finding that since we had not pleaded about this document in our Order 41, Rule 27 petition, as such, this documents could not be considered. But however, if my lord peruses order for, the review provision, my lord, it says that one of the grounds of review is that if certain new evidence or documents come, then we can, of course, go for a review, my lord.
That's all right. The question is, the observation made by the appellate court is that SBI is not the authority to give such a finding whether the petitioner, the lady was literate or illiterate.
Yes, my lord, that is agreeable, my lord. That is not the authority, literate or illiterate. What is stated is that no signature of the petitioner's mother is recorded in the bank account. No signature is recorded as because she is illiterate. Now, if the other side is harping on the point that I am literate, then they ought to have produced that any such school certificates or everything, because I being an illiterate or not being literate is a negative fact. I will not be able to prove that. However, this raises a strong presumption or gives a probability that my mother, it gives a strong probability that I may not be literate, my lord. So this is a piece of evidence that will stand to scrutiny of the process.
The case is pending now.
Sorry, madam.
At what stage the case is pending now?
Final hearing, my lord.
Hearing?
Yes, it's fixed on 18th.
Before the appellate court?
First appellate court, DFU, madam.
Let notice no, it is, we'll hear both the sides.
Until next day, my lord, the proceedings be stayed because they will not entertain our prayer to further adjourn the matter. And my lord may be pleased to see this is a second round of litigation. Annexure 10, my lord, page 106. Earlier also I had filed the case, but due to some formal defect, I had to withdraw and then refile the thing. As such, a certain amount of time has elapsed and many more adjournments have been taken, stating that the case is pending in High Court. But stay needs to be there, madam. Till the next date, madam.
Mr. K.R. Borua, learned counsel. In this petition under Article 227 of the Constitution, the petitioner has challenged the order dated 13/10/2023, passed in petty level number 5 of 2022 by the learned civil judge senior division Karbi Anglong Tipo, whereby the learned appellate court has recorded a finding while partly allowing the petition filed by the petitioner herein for tendering additional evidence. And also the order dated 21/8/2024, passed by the learned civil judge senior division Darby Long People in Misja case number 14 of 2023. Arising out of title level number 5 of 2022, whereby the learned appellate court has rejected the pair for review of the order dated 13/10/2023, passed by the learned. The first in title appeal number 5 of 2022 by the learned civil judge senior division Darby. There is the petition and the documents placement record, and also there is the impugned order dated 13/10/2023 and 21/8/2024. Let notice be issued to the respondents, return equivalent for weeks, step be taken by registered force with AD and also by usual process. We come to that. Mr. Borua, learned counsel for the petitioner, submits that the petitioner has already availed several grounds, several adjournments before the learned appellate court, and if he tries for further adjournment, there is every likelihood of rejecting his peer, and as such, he tries for staying further proceeding of title level number 5 of 2022 pending before the Court of Learned Civil Senior Caribbean. We are taking note of the submission of Mr. Borua, learned counsel for the petitioner, and also considering the facts and circumstances on the record, further proceeding of title level number 5 of 2022 stands state till returnable date list of the courts.
Highly obliged.
Item number 43.
May I please, your lordship? My lord, we have filed this application against the order passed by the Munsef Amingaon, rejecting my prayer for stay of the execution process. What happened is this, my lord, a small facts is this, my lord. One Jumur Ali had died leaving two sons, Kutubali and Itapali. He had some land measuring 16 vega 4/14 acre. And my lord, the land was ultimately partitioned between the Kutubali and Kitapali. My lord, they have the heirs of Kitapali filed a suit that I am dispossessing the plaintiff, from the suit land, and therefore I shall be evicted. Their prayer before your prayer in the plaint, your lordship kindly see at page 33.
Yes.
A decree for declaring right title interest in respect of Schedule A and B. Schedule A and B for declaration that the dependent number 1 to 3 have undivided right, title and interest and possession over the Schedule B land, and the dependent number 4 to 9 are the trespassers to Schedule A land and liable to be evicted from Schedule A land. Decree for ejectment of dependent number 4 to 9 from the Schedule A land along with their man, materials, etc., etc. A decree for permanent injunction. Next page, your lordship, in the suit, I'm sorry, my lord, sorry, copy of the plaint. Sorry, paragraph 26.
Yes,
Sorry, sir, page 26. A decree for right title interest of Schedule A land. A decree for declaration 26, your lordship can see. A decree for declaration of right title interest of defendant number 1, 2, 3 of the an undivided right of the Schedule B. Defendant number 4 to 9 are the trespassers. Schedule A land liable to be vacant. Ejectment of the defendant number 4 to 9 from the Schedule A land. Permanent injunction. Well, so far the Schedule B land, so far the Schedule B land is concerned, the plaintiff paid for undivided right over the Schedule B land. And in the plain, there is no Schedule A mentioned, only Schedule B mentioned at page 27. A plot of land measuring 1 bigha 1 kata 11 lesa covered by so and so. Dag number land measuring 1 bigha 3 kata 9 lesa covered by so and so. My lord, this Schedule B land, now they want to take prayed for joint possession of the Schedule B land. Thereafter, my lord, the suit was decreed by the trial court, holding that the yes, page 20, page 22, your lordship can receive. Their facts has been stated. Thus, the plaintiff and the predecessor of defendant late Kutubali became the co-owner of the land measuring dag number 31, which contains the land measuring 1 bigha 1 kata 11 lesas, and dag number 32 contains the measuring of 3 kata 9 lesas of KP Patal number 204 of Sodri Palm Golemari in the district Kamrup, which has been described in the Schedule B. This the dependent number 1, 2, and 3 surreptitiously and illegally mutated their names in the revenue record and the entire land of dag number 31 and 32 by cancelling the name of the plaintiff. Although the plaintiff number 1 and the dependent number 1 to 3 are the co-partaidors of the land of dag number 31 and 32. Therefore, the plaintiffs has paid for declaration of right title interest over the land of dag number 31 and 32 and paid for issuance of precept to the Revenue Authority for cancellation of the mutation of 1 to 3 of dag number 31 and 32. Similarly, the dag number 162 of Pata number 204 contains 2 bigha 1 kata 1 lesa land. The plaintiff has portion of the land 1 bigha 1 kata is forcefully occupied by dependent number 4, 5, 6, 7 with the assistance of the dependent number 1, 2, and 3 described in the Schedule A of the plaintiff. The plaintiff sought for declaration of title of the heirs of Kitapali and also sought for relief of the ejectment of the 1, 2, 3 from the Schedule B land. And dependent number 4, 5, 6, 7 Schedule B. Already so far the land is concerned, the plaintiff sought for declaration of recovery of possession of Schedule A land. Schedule A land, there is no mention in Schedule A in the plaint. And I got the certified copy and I have not found the Schedule A. Prayer number 1, recovery of possession of the Schedule A land. But there is no Schedule A land in the plaint. Schedule B land is DAG number 31, covered by so and so. Under the execution petition, execution petition.
Oh, here the impugned order is dated 26/5/2025.
Yes,
It was passed in execution proceeding.
yes.
So what wrong with this order?
It is wrong with this, my lord. They prayed for recovery of possession of Schedule A land. But they put the schedule of the schedule in the execution petition, the Schedule B land. Schedule B land, they have prayed that they have undivided owner of the land, along with the defendant number 1 and 2. Therefore, the whole execution case is they are misleading the court by putting Schedule B in the execution petition and got the executed the decree partly. When I filed the petition before the court, the learned executing court rejected our prayer. Therefore, the whole thing is this, my lord, the decree holder plaintiff, by misleading the court, got a decree so far Schedule A is concerned. And they, in the execution petition, they put the decree of Schedule B. By putting the decree of Schedule B, the court, the Nazir of the court, partly executed, partly evicted us from the Schedule B land. Therefore, That point I was raised by under section 47. The learned trial court, without giving any hearing, the petition was rejected.
No, on the date of passing the impugn order, both the parties were present before the court.
That order was passed after partly executed the decree.
Hmm.
When we were evicted, partly evicted from the decree.
So when
then
you
we
have
filed a
filed the
petition.
petition under section 47.
Yes. Section 47 petition is at what? 60.
Page number
60.
16.
No, 60.
60. But it is indicated that the executing court has heard both the parties.
Yes.
Come to page number 73.
Heard both the parties. And my lord, he has not given, see, the executing court has not given any finding. The petition number 1254 is rejected. 1254 is prayed for stay of the execution decree. Whereas it is rejected.
But in the meantime, decree is partly executed.
No, my lord, the decree was executed as per report of the Nazir. But the decree holder filed a petition that it is not fully executed. Therefore, court has issued directed the Nazir to re-execute the decree. Therefore, I have come that this order is apparently illegal and this should to be reviewed by this honorable court. Whether the schedule of the land is correct or not, whether the after execution of the decree can a fresh writ can be issued for the execution of the decree. Because they have prayed for eviction of defendant number 4 to 9 and I am 1, 2 and 3. I am the owner of the land. And they, by executing the decree holder evicted me also, including the defendant number 4 to 9.
No, as per this order, whatever is there in the decree, it was directed to be executed.
No matter when I filed a petition under section 47, the court is to hear and if necessary is to record the evidence, whether the decree is executed or not, whether it is partly executed, whether we have right or not. That part was not considered. Only the hearing of both sides, this petition cannot be secured. Because I am the owner of the land. Along with the plaintiff.
And that's all right. The court has observed that it cannot go behind the decree.
This observation of the court is wrong. Because when they have stated in the plaint that the defendant number 1, 2, 3 have the undivided share over the land, then how the defendant number 1, 2, and 3 can be evicted from the land along with the 4 to 9? 4 to 9 trespasser, I have nothing to say. So far my right is concerned, because I am the heir of the Kitapali, Kutubali, therefore I have some share in the land and I cannot be evicted from this land. That part the executing court has not considered.
No, that's all right. What the executing court has directed that what is there in the decree that has to be executed.
No, it is
Have
the
you
duty of
prepared
the
any appeal or review or anything against the judgment and decree? No.
That was, huh? And they were going to file the decree because it is an expected decree. We had no knowledge of the suit. Because when we came to knowledge, we are preparing to file an appeal. My lord, my prayer is very short and simple. My prayer is this: partly decree has been executed, and a notice may be issued to the opposite party. They say what is what. Till then, the execution may be stayed.
Who can let the other side appear? We will consider the state thereafter.
No, my
At
lord,
this
then
stage,
the
let notice go.
no, my lord, what happened is this, my lord. There is an urgency. Urgency in a sense.
We will fix a very short date. You serve the
I mean,
notice
till then, I may not be disturbed. Till then, I may not be disturbed from the suit line.
We will consider your interim pair after appearance of the other side.
My
You
lord,
file a petition before the executing court that one civil revision petition is pending before this court.
my lord,
Because it is at the last stage of the execution.
my lord, it is a fraudulent decree. It is a fraudulent decree.
No. We cannot consider that a fraudulent plea at this stage. You have never prepared any
My lord, it is
appeal or review petition
my lord,
or for recalling the ex parte decree or order.
my lord, a short date may be given. We will serve the notice by dusty. And till that, my lord, my position over the land may be protected.
Third
in
is
a week or 10
S.C.
days.
Sharma, Learned Senior Counsel, assisted by Mr.
Ian.
Learned Counsel for the in this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 26/5/2025 passed by the Learned Civil Judge Junior Division Kamru Babington in title execution case number 7 of 2023. Is to be noted here that by the impugn order dated 26/5/2025, the Learned Civil Judge Junior Division Kamru has dismissed the petition filed by the petitioner hearing under section 47 of the CTC. After hearing learned counsel for the petitioner and also considering the facts and circumstances on the record and further perusing the Order dated, impugned order dated 26/5/2025. This court is inclined to issue notice to the respondents returnable in 4 weeks. Sorry. Next date is fixed on 19.
Yes.
We'll fix it on 18. Returnable on 18. It's the bid ticket by registered post with AD and also the usual process. Within 2 working days from today. Justice service is also permitted. Interim period of the petitioner will be considered after appearance of the other side on 18.
Dismissed, appeal was dismissed, then division was dismissed, and they went to Supreme Court. That Supreme Court judgment is at page 49, my lord. I want to show a few sentences from there, my lord. 49. If your lordship comes to page 51, the last 4 sentences, defendant number 2 got himself implemented in the suit claiming to be necessary party if it was permitted. The respondent filed written statement and non-material averments of the claim. Now, if your lordship may come to page, my lord, 56. Now, first para, last 5 sentences, my lord, 6 sentences. In other words, it was in relation to the question as to whether the plaintiff was able to prove the relationship of landlord and tenant between him and the defendant number 1 in relation to the suit premises. Indeed, this was one of the main questions involved. This question, the first part of the issue number 4, was decided by trial court in plaintiff's favor, wherein it was held that defendant number 1 was the plaintiff's tenant. So far as the second part, the issue number 4 is concerned, in relation to the question as to whether defendant number 1 was defaulter in payment of rent the plaintiff. This question was answered by the trial court against the plaintiff and in defendant 1's favor. When it was held that defendant number 1 did not commit any default in the present case. Now, my lord, this was the case, my lord. Now, if your lordships, my lord, come to the impugned order, my lord, which is at page 155, my lord. My lord, they wanted to execute the decree against me also, although there was no decree against me, my lord, actually. Because I was not a party to the suit, they did not claim anything against me. I shall place that, my lord, here. If you'll also see, my lord, we file a petition under section 47. I start from the last 8 sentences, my lord. Your Honor, may father be pleased to, you'll also got it. Your Honor, my father pleased to dismiss the above executed case as the impugned decree itself is null and void, not binding upon the JD petitioners. In upon perusal and in consideration of the said report, if it is found that the business of the prisoner, Schedule 1 below has been included in the boundaries of the schedule decree, when admittedly decree holder or their predecessor has not filed any suit, any claim in respect of the business premises of the judgment debtor, as they have admitted in evidence recorded in the original title suit. The predecessor of the petitioner, J.D. Shiv Shankar Sarda, during his lifetime, took settlement of the land described in the Schedule 1 below from the owner thereof, Narasingha Vigraha, the deity represented by its civil. The aforesaid land let Sarda operated the business of retail sale of cloth material under the name and style of Sarda Textile. On 6/7/72, there was a devastating fire in Tulapatti area. All the houses number where dark number so and so were completely gutted. Thereafter, the aforesaid led Shiv Shankar Sarda at his own expenses constructed permanent house over the half of the 1 Katha and 5 Chatak 10 Gondas land described the Schedule 1 below and started doing business there. Let Shiv Shankar jointly with his uncle Devchan Sarda obtain lease measuring 1 Katha 5 Chatak 10 Gondas covered by dark number so and so for a period of 21 years, and such land is included in the land described in the schedule. Now your losses may come to next page, my lord, 158. 158, last sentence, my lord. It is pertinent to consider
that the aforesaid Surendra Sukul is the plaintiff, my lord. While deposing as PT1 in the aforesaid title suit in the court of the Munsif number 2 Kachar, Silchar, during his cross-examination categorically admitted that he does not have any claim of any nature against the defendant number 2, Sipsanksa Sarda, and the predecessor in interest of Krishna JD. But the description of property involved the aforesaid so and so attacks the schedule over the land so and so. Now, the losses may again come to last 7 sentences, my lord. Last para. In this aspect, it is necessary to mention that while instituting the title suit number so and so, the said Surendra Sakal gave description of the scheduled premises without mentioning the quantum of land, without proper measurement, without mentioning the dark number, patna number, and his specific identification. He merely mentioned the holding number and ward number, patna number, without any premises. The description of premises as mentioned so and so school is plain of the aforesaid is reproduced below. This is the my lord. Now, second para. It is necessary to mention that as this suit proceeded without impleading necessary party. Surendra and Sukul, the original plaintiff, ought to have impleaded Sri Narasingha Vigraha, the owner of the land, as necessary party. Further, it is pertinent to consider that while dismissing the civil revision, Honorable High Court was pleased to observe that the lease deed executed on so and so has not been challenged by the plaintiff, and thereafter the plaintiff would not prove the tenancy continued even after the incident of fire faced by the aforesaid Devchan Sarda so and so so and so. Now, one paragraph you may escape over. Next paragraph. It is also necessary to mention that Surendra and Sukul took settlement of the land measuring 6 justi equivalent to 5 kathas 3 chatak of the land from deity Narasingha Vigraha. Out of such land, a portion of the land measuring 2 katha 5 chatak 3 gandas was sold by Surendra and Sukul in favor of one Krishna Roy on 1/2/62 by registered sale deed at the office of the Joint Sub-Registrar Silchar, and remaining to so and so land is in possession of the legal heirs of the aforesaid Surendra and Sukul, and during the lifetime Surendra and Sukul continue to use and enjoy and occupy such portion of the land with houses thereon. The plaintiff Surendra and Sukul would not have got the benefit of his own fraud by claiming land beyond the alleged settlement. It is specially mentioned that the land and house of the was in possession of Sipsang Sarda and now in possession of the petitioner's JDs outside the leasehold of the aforesaid Surendra and Sukul. It is pertinent to consider that while submitting the written statement in the so and so, and in which he was impleaded later on, aforesaid Sipsang Sarda especially pleaded that the original plaintiff Surendra Sukul instituted a suit collusively defendant number 1 in that suit in order to deprive the aforesaid Sipsang Sarda, the predecessor interest of the present plaintiff, from the aforesaid land and the house in thereon, and that there never existed any landlord-tenant relationship of the said Sipsang Sarda with the aforesaid Surendra Sukul. Narayan Sukul, during his evidence, when he stated that he had no landlord-tenant relationship with Sipsang Sarda or his father, Motanchan Sarda, during his deposition, he further admitted that he did not pray for cancellation of the lease deed dated 29/7/76, and further, he never prayed for eviction of Sipsang Sarda, and he did not file any suit for declaration of title as a consequence of denial of title by Sipsang Sarda. He further admitted during his evidence that he did not construct the room on which Sipsang Sarda had been doing his business, and that he did not file any rejoinder of the pleadings after impleadment of Sipsang Sarda was made in the suit. It is further necessary to mention that, according his deposition, Surendra Sukul never claimed any relief against Sipsang Sarda. Such fact was observed by the Honorable Appellate Court, that is in civil judge number so and so, in appeal arising out of Arbitrary number so and so, that no relief was sought as against Sipsang Sarda. I'm just skipping over now. Your losses may come to next page, my lord. Line number 6, my lord. 164. But you also got it, my lord, unfortunately. Page 164.
From top of the or from bottom.
Yes, I can read. Huh?
From the top. From the top.
Yes, from the top, my lord. Petition number so and so brought Honorable Guwahati High Court. After hearing both sides, Honorable Guwahati High Court was pleased to allow the revision order so and so by which the trial court was directed to purge survey of the land as above. But unfortunately, Sipsang Sarda expired in December 1982, and before impleadment of the petitioners, JDs, and before they could understand anything regarding the filing of the return statement by the Substitution Sada, Surendra and Sukul, in collision with the original defendant number 1, that managed to obtain an order of survey of the land, misguiding the land trial court, and behind the back of the plaintiffs, managed to obtain false fraudulent policy report. Such report reveals that the premises measuring 22 feet by 32 feet, bounded on north by property, south by house of plaintiff, Surendra Sukul, north by New Variety Store, and west by Sada and Company, was under occupation of Substitution Sada by constructing house of his own on his own strength, on the strength of this deed executed by Narasingha Vigraha. It is pertinent to mention here and there. Recently, some of the prisoners received summons from the court of civil judge number 1, Kachar Silchar, in connection with title suit number so and so, filed by Narasingha Vigraha as plaintiff against Biswajit Sukul and others. And the above case of the said suit, Narasingha Vigraha took that that plaintiff of the suit paid for a decree against the opposite decree holder above named on the following delete. This is another suit, my lord, filed by Narasingha Vigraha against the decree holder. Now I am speaking over, my lord. This is not necessary. Now your losses may come to page 168, my lord.
Yes.
As because the property described in the Schedule 1 below is situated in the boundaries of declared property. In case of execution of the decree obtained, so and so in court of Landlord-tenant number 2, renamed as civil judge number 2, Kachar Silchar, obtained on the strength of the aforesaid judgment on order so and so, in aforesaid CRP number so and so, there is no reasonable apprehension. There is reasonable apprehension in the mind of the petitioner JD that they will be evicted during the implementation of the decree as aforesaid. Although as per admission of the predecessor of the decree holder OP has aforesaid, the decree cannot be proceed involving the said property of the petitioner JD as described in the Schedule 1 below. In true sense, the decree described in Schedule 2 below is illegal and non-est in the eye of law as against the petitioner JD's against Schedule 1 property. And if the said decree remains outstanding, it will cause for loss the petitioner JD, and hence the decree described in Schedule 2 below is liable to be judged an illegal, void, honest, and not binding upon the petitioner JD. Otherwise, petitioner JD will suffer about loss and injury. Now, this is the my lord matter. Now, my lord, your losses may come to page 170, my lord. Top, my lord. As because decree holder OPs have been taking preparation to proceed the execution case on strength of the decree described in Schedule 2 below, which will affect the valuable property of the prisoner described in Schedule 1 below, it becomes essential to grant injunction against the from proceeding with the execution case as against the petitioner JD involving the property in Schedule 1 below. Otherwise, petitioner will be evicted. Now, this is the case of the my lord. Now, my lord, your losses may come to page 172. That in any view of the law and fact, the impugned decree is not executable and accordingly liable to be dismissed. Copy of the petition received. I have heard so and so. Then, my lord, the present case, nothing is, my lord, considered. In the present case, the last para, civil appeal number so and so, Supreme Court of India was heard in presence both the sides. At that time, the petitioner never challenged the identity of the suit property. Hence, the petitioner are now stopped from raising the new fact. The Supreme Court has said there is no relationship of landlord-tenant so far defendant number 2 is concerned. My lord, how a decree which is not passed against me, my lord, can be executed, my lord? And this, my petition under section 47 has been dismissed. Even a case, my lord, suppose a person is not a party, he can file a petition, my lord, under Order 21, Rule 9799. PLOC knows, my lord, that he is holding the property of his own right. Here also, he is holding the property of his own right. There is no decree so far petitioner is concerned. So, if section 47 is virtually is a case, my lord, Order 21, 9799. So that point is to be decided by the executing court, my lord, because in the petition under Order 21, 9799, that is to be decided as a suit, my lord. Here also, my lord, the same thing is there. What he has decided? Just he has said, my lord, we have not disputed, my lord, the identity of the property. Well, when there is no decree, my lord, against me, how a decree can be executed against me? There is no relationship to landlord-tenant, my lord. And that Supreme Court has also, my lord, observed that we have been raised a party. The dispute was only with regard to this defendant number 1. let him merely execute the decree against defendant number one, my lord. How he can execute against defendant number two or his legal heirs, my lord? Well, this is a case, my lord. My humble submission, my lord, this is a absolutely illegal order, my lord. He has not considered anything, my lord.
But defendant number 2 is in the same plot of land which was
My
earlier
lord,
given
it's
to
not
the
my lord.
defendant number 1.
If your lordship see, my lord, he is given a vague plot of land, my lord. But I am there of my own right. He has said, my lord, he himself has admitted, your lordship has seen, my lord, his observation, that he is not claiming his right, my lord. We have constructed our own building, my lord. And they have not challenged the.
You tell me whether he is in the same plot of land which was earlier given to the defendant
My
number
lord,
1.
I can't say, my lord, that is a vague
You
plot
can't
of land. That is why I'm saying, man, page 28, my lord, your lordship see. My lord, that is the thing, my lord. How much land, what's the part, my lord, that thing is there. Nothing is there. And they have done some, my lord, there's some behind my back, my lord. That is the question, my lord. Here, my lord, the vague, my lord, only boundary has been given, my lord, and holding number. My holding number is also defined, my lord. Page 28, my lord, your losses may come to plaint, my lord. Page 28 of the plaint. When he has not paid for any decree against me, and the plaintiff knows where I've constructed my house. He knows everything. I'm taking the lease, my lord, I have constructed my house. He knows everything. But even then, he has in the evidence, he said that no, I'm not paying for any decree against defendant number 2. There is no relationship of landlord and tenant. My decree can be executed against me, my lord. This is a vague, my lord, page 28, my lord. Survey was done behind my back, my lord.
Mr. Sariola, you see, holding number is there.
Holding number, my holding number
Boundary
is not
is
this.
there.
Yes.
The suit land is identifiable.
Suit land, my lord, they have a vaguely, my lord, they have given, but he is not taking the entire land, my lord, because that belongs to the deity. He has given the, my lord, how much land he has taken on land. Now, part of the has been sold. That has been discussed by the executive court. And part is with him, my lord. They does not take this, my lord, entire land. That is my question, my lord. And without a decree, can it be executed against me, my lord?
No, that is well settled. That unless a decree is passed against you, how can it be
My lord.
executed against you?
So they have to, my lord, if anything is there, because when the suit was not filed and the plaintiff, original plaintiff himself has said, that no, I'm not paying for any relief against the defendant number 2.
Okay. Yes, what is your?
I respectfully differ with Landlord Senior Counsel Lordship.
Pardon?
I respectfully differ with all these facts have been placed before. Suit was under Urban Areas Land Control Act. It is not in respect of land, house. It's room. Now, suit, as Lordship has already seen, in respect of holding number 258. Now, if the defendant number 1 inducted him in 258, he is also responsible for the decree. And he all along contested the decree. He filed written statement. The original defendant number 2, the predecessor of present these petitioners, they never disputed this. This is not 258. Now, decree is in respect of holding number 258. And their petition, Lordship, if I may take your Lordship to their petition, in execution petition 47 is at page 114. Lordship may come to page 128. They have also given a schedule.
Yes.
128. There is old schedule 1, Lordship, who is claiming that. There is, Lordship, holding number 257 old is mentioned. And our decree is also over 257. So he is in 257. He is in holding number 257. How he has entered there, and that is why perhaps there given number 1 and 1 is his uncle. So there is some collusion between them. He has entered. We let out the premises to defendant number 1. Accordingly, we filed the suit for eviction against the defendant number 1. Defendant number 2 implemented himself, filed written statement. And in the written statement also, this is regarding this lease of land, etc. was there. These were considered by the, after dismissal of suit, by the first appellate court, then by the High Court. All those has been rejected by the Honorable Supreme Court. So they cannot claim these things again. Honorable Supreme Court has says that there is a landlord-tenant relationship as held by the trial court earlier. They have not filed any appeal against them, so they cannot reopen it. Now in execution proceeding also, they cannot reopen it. The scope of under section 47 is very limited and narrow. If the decree is without jurisdiction and nullity, then it can be looked into. Now they were all along party contested the suit, revision petition before the Supreme Court also. And after Supreme Court remanded this the case again to the first appellate court, and there was a decree. First appellate court allowed our appeal, and the revision petition was also filed by the defendant number 1. And in this revision petition also, these facts of that lease by the deity itself regarding land, this was discussed, and it was held that already Supreme Court has decided this issue. Now, suit property is, decretal property is this holding number 257 old. Now he is also claiming holding number 257 old. There is a decree, and he was a party all along to the suit, appeal, etc. all along. Nothing was in his absence. So,
But you have admitted that there is no claim against the defendant number 2.
no, this has been discussed by already. Now executing court cannot go behind the decree, lordship.
No, that's all right. That is well settled.
These things,
But you have admitted that you have no claim against him.
now this is our case in the first appeal also. First appeal, then in the CRP also. But Supreme Court said these things you cannot claim here. You have not filed any appeal or cross objection to our appeal. So this has been, now they are stopped from claiming this. Now, question is, defendant number 1 was let out the room. And if defendant number 1 has inducted defendant number 2, or any person through him is liable for eviction, because there is a decree in respect of holding number 257 premises. And their case is not that this is without jurisdiction, it is a nullity. This is not that. And it cannot be, because they are all along to the party. And this is a settled law, lordship. There are many decisions, if I may. The scope under section 47 is very limited, lordship.
No, that's all right. Now you tell me whether we can finally hear and dispose of the petition today.
It can be, because I am appearing for the decree holders. Decree holders, they are agitating against me. If lordship wants to post it another day, it's okay, lordship. Because notice is not required to be issued.
Yeah, any day may look maybe fixed, my lord, really.
After
Vacation, my lord.
vacation. Today, let notice go. One caveat is also there.
Yes, caveat is to be discharged.
Caveat or they heard caveat. Heard Mr. Ian Sayola, learned senior counsel assisted by Ms. Bhattacharya. Learned counsel for the also heard Mr. As the professor learned counsel for the this petition under Article 227 of the Constitution of India. Dated Section 151 of the Code of Civil Procedure. The petitioner has challenged the order dated 8/5/2025, passed by the learned civil judge, Junior Division number 2, Passer Civil Sir. In miscellaneous case number 138 of 2024, entitled execution case number 55 of 2023. Thereby dismiss the case number 138 of 2024 filed by the petitioner under section 47 of the Substitution. Where is the petition and the documents plus the record? Let notice be issued to the respondent. Returnable. Okay, accepted. 21st July.
Lord, he is appearing for 2
Notice may go to only respondent number 1 and 14, Lordship.
1 and
1 and 14.
1 and 14.
1 and 14 and,
However,
and 19 to 26.
no formal notice is required to be issued to respondent number
2 to 13
2 to 13
and 15 to 18. 15 to 18.
Notice.
Ah.
However, extra requisite copy of the petition be furnished to him during the course of the day. Step upon respondent number 1 and 14.
1, 14 and 19 to 26.
1, 14, 19, and 19 to 26 shall issue by registered to with AD and also by legal process within a week from today. List on switch.
My lord, interim, my lord, your lordship, my lord.
That day, interim petition, interim payroll will be considered on that day.
Well, till then, my lord, till then status quo will be maintained.
Lordship, there are other petitions also filed by the this Northing Bureau under section 47 there.
That is another aspect of matter.
So it is pending. If it is state, Lordship, everything will be state.
No, I'm
Since
not.
1977,
I'm not for
it has been
stay.
50 years, Lordship.
I'm not for stay. Status quo will be maintained, my lord, so far.
Lordship.
On that day, we will consider.
No, status quo, my lord. I'm not
No,
paying for stay.
no,
My lord,
no.
status quo,
Till next day, definitely decree will not be executed.
my lord,
They may file.
no,
petition
nobody can say, my lord.
is pending.
No, as submitted by him, some petitions are still to be.
My lord, execution is the date is fixed, my lord. No, last of June, my lord. That
No,
is
no,
fine.
that's all right.
My
But
lord.
some petitions are pending.
Pending,
before the executive.
Petition, my lord, I don't know, my lord, what petition is.
Yes, I
filed.
have instructed.
No,
Lordship,
maybe,
there are petitions
my lord,
pending.
they might have
Similar
filed, my lord.
petitions. It will take
Might
time.
be this, my lord. So status quo will not hamper his,
So
my
once
lord.
the status quo is granted, it will continue, Lordship.
No,
Okay.
so far petitioner is concerned only. Petitioners are concerned.
So petitioner are also liable to be this. The holding number 257 is involved, Lordship.
On next day, we will consider it.
Having added 7.
Much of it.
May I please? My lord, this petitioner agreed, my lord, in filing WS against counterclaim, there was a delay of 10 days, my lord. Was not considered, my lord. Impugn order, page 90, my lord. In fact, my lord, the learned court below wrongly observed that there was a delay of 15 days. There is no delay of 15 days, my lord. I am showing, my lord.
Interim order is at, no, sorry, impugn order is at page number
90, my lord.
90. So how the delay of 15 days occurred?
My lord, learned court below counted Saturday, Sunday, and holiday of Dol Jatra. When that is, my lord, March 23, 24, 25, 26. All are, and my lord, WS file on 27. It is a reopening day. Page, my lord, I have enclosed, my lord, the High Court holiday list, my lord, page 84, and 7. The holiday list, my lord. And that, my lord, holiday also.
So, no, who is that? It was holiday?
My lord, 23 was for Saturday,
23.
24 Sunday, 25th and 26th holiday for Dol Jatra. March.
25th, 26th, and 27 were
On
Dol Jatra.
27, my lord, it was filed. That was the reopening day. And while calculating,
That
my lord,
holiday list is at page number?
page number 84.
Pardon?
84, my lord. Holiday list of Honorable High Court and holiday list of court below also I have enclosed, my lord, 84 and 85. 85, my lord, Dol Jatra, 25th and 26th March. Page 84. 84 and
So,
85.
you have filed it on 25th or
27. 27.
27.
Yes.
And 23rd, 24th, 20.
Should be, should not,
Those are holidays.
should not be counted, my.
Yes.
The general.
Thereafter also there remains 11 days.
My lord, yes, these holidays also counted, my lord.
No, no. Thereafter also 11 days remain.
10 days, my lord. And I have, my lord, stated in my petition for condemnation of delay, which is, my lord.
So, how this 10 days is explained? 10 days are explained?
My lord, yes. I have my petition is page 71. In paragraph 4, my lord, I have explained it. At page 72, paragraph 4.
70?
Page 72, my lord, this is my petition for condemnation, paragraph 4.
Yes.
Paragraph 4, that in the normal course of counter written statements should be submitted and 12/3/24, but the counterclaimant could not have been traced out. Just on 18/3/24 could be traced out the same in preparation of the counter statement and typing took 4 days, and as such there was remain clause for 23 to 26. Clearly mentioned, my lord, due to 4th Saturday, Sunday, and Dol Jatra. So counter written statement could not be submitted in those 4 days. Hence, the reason for cited 10 days is delayed in submitting the counterclaim. This is my case, my lord. And my lord, in the impugned order, my lord, page 93, quote below says that it is saying that the petitioner could not place reasonable and sufficient cause
No,
for.
is it properly explained? You see, this counterclaim could not have been traced out.
My lord,
Just on last 18/3/2024, it could be
my
traced.
lord, it was served to the counsel of the petitioner. And my lord, my lord, it is the mistake committed by the counsel, my lord, not by the petitioner, that he could not trace out from his file the copy of the counterclaim. It is paragraph 4 says so, my lord. And
Okay, you pay some cost. We will condone it.
as you lord, as you lord.
Pardon, sir, as so one learned counsel for the petitioner. This petition, Article 227 of the concept. Yeah. The petitioner has challenged the redo it section 115 of the CPC. The petitioner has challenged the order dated 3/3/2025 passed by the learned civil judge junior division of Dalbury in midday case number 08 of 2025. It's to be noted here that by reviewing order dated so the learned civil judge junior division of Dalbury has refused condone the delay of 10 days in filing the written statement against counterclaim.
My lord, against counterclaim.
Counterclaim. Mr. Sohan, learned counsel for the petitioner, submits that while dismissing the petition filed by the petitioner on 19/4/2024 under section 5 of the Limitation Act for condonation of delay of 10 days. The learned trial court has counted the 4 holidays also, and then the petitioner has submitted the written statement against the counterclaim on 12/3/2024, but the engaged counsel could not trace out the same, and the same could be traced out only on 18/3/2024. 18/3/2024, and thereafter on account of holidays, he could not file the same on 23rd, 24th, 25th, 26th March of 2024, but he could file the same on 27th of 2024. And in the meantime, delay of 10 days occurred, and the same is not intentional. and the petitioner is not responsible, rather his engaged counsel is responsible for the same. That for the fault of the engaged counsel, the petitioner should not suffer, and therefore Mr. Sohan is contented to allow the petition. Having heard the submission of Mr. Sohan, learned counsel for the petitioner, I have carefully gone to the petition and the documents placed on record and also for the order dated so. Taking note of the submission of the learned counsel for the petitioner and also considering the explanations so forthcoming, this court is of the view that the delay of 10 days in filing the written statement in the counterclaim is sufficiently explained. And as such, this court is inclined to allow this petition by confirming the delay of 10 days in filing the written statement against the counterclaim. However, the petitioner has to pay the sum of rupees 2,000 being the cost which shall be deposited before the Secretary, District Legal Service Committee of Udalguri within a period of 1 week from today. In view of the order, now in view of the condonation of delay of 10 days, now the trial court shall proceed to accept the written statement filed by the petitioner and thereafter proceed to hear the matter in accordance with law in terms of about this law. That's this one.
Much obliged. Items for admission. Item number 13.
Yes.
Lordship, already we have made the payment. There was a commercial suit in the trial court. We have already made the payment and they will be withdrawing the commercial suit in the civil judge senior division.
Yes.
My lord, we are the original plaintiff in the commercial suit at Jorhat. So we have received all the payments they have cleared all the payment as mandated. So we are going to withdraw the suit next month. It's posted in the month of July in the senior civil judge senior division at Jorhat. So on that day, sir, my lord, we're going to withdraw this suit against them. So we have got no claim against the defendant in the principal suit. So accordingly, this appeal also becomes redundant now because we are going to because we are going to withdraw the parent commercial suit in Jorhat next month, Your Honor.
Or Mr.
W. Hawk on behalf of Mr. A. Sattar.
Learned counsel appearing on behalf of Mr. A. Sattar, learned counsel for the petition, and also heard Mr.
J. Borua.
J. Borua, learned counsel for the response. The learned counsel for the petitioner submits that the petitioner has already made payment of the entire amount to the respondent herein, and the respondent herein will withdraw the suit on next date from the learned in the court of learned. Where it is pending.
Civil judge senior division.
Senior division, Jorhat.
Jorhat.
And as such, this petition becomes success.
The commercial suit number 14 of 20.
Closed. Thus taking note of the submission of learned counsel for both the parties. This shall be file number 368 of 2024 stands closed.
Item number
Obliged, Lordship.
15.
May it please your lordship. Your lordship, the main two grounds in this appeal is that the first ground is that there was a delay in lodging the FIR a delay of 51 days. And the second ground is that there wasn't any psychiatrist present in the medical board at the time while examining the claimant. And therefore the disability certificate ought not to have been considered. Those are the main two grounds.
Pardon, sir, has got the learned counsel for the appellant, Mr. Talukdar for respondent number
One, Lordship.
respondent number 1. This appeal under section 173 of the Motor Vehicle Act 1988 is directed against the judgment and award dated 3/2/2024 passed by the learned member, Motor Accident Claim Tribunal, Nogao in MSC case number 20 of 2021. It is to be noted here that by review judgment and award dated so the learned tribunal has directed the appellant herein to pay a sum of rupees
7,77,106.
7,77,160.
Yes.
Take the compensation to the respondent number.
One.
Respondent number 1. Respondent number 1. With interest at the rate of
Interest 9% per annum.
6%.
rate of 9% per annum from the date of award. Date of award.
Not 6% per annum. Correct.
No, you come to page number 22.
22, Lordship.
Yes. At the rate of 9%.
Lordship,
That is penal
Seventh line.
interest, your lordship.
Paragraph
Okay.
34.
6% per annum from the date of claiming, date of filing the claim petition. Then, if the amount is not paid within 3 months, then the interest shall be calculated at the rate of 5% per annum. Where is the memo of appeal and the grounds mentioned therein?
In page number 5 of the appeal.
Issue notice to the respondent returnable in 4 weeks. Should be taken by registered post by AD and also by legal process upon respondent number 2.
Yes.
However, no formal notice is required to be issued to the respondent number 1 since Mr. Talukdar entered appearance and received notice. However, extra requires a copy of the list of purpose. Is there any I?
Yes, your lordship.
I number?
I number 1879 of 2025. That is for stay
Mr.
of
Talukdar, any objection?
Granted subject to deposition of 50% of the earlier. And the claimant referendum to may be allowed to withdraw the check.
16. This is an appeal on quantum, means injury, non-fracture crash injury, and the amount is 21 lakh something.
Heard Mr. R. Goswami, learned appellant, and also heard Madam
Respondent number 1, M. Dasgupta.
N.
M. Dasgupta.
M. Dasgupta, learned counsel for the respondent number 1. This appeal under section 173 ME Act is directed against the judgment and award dated 19/12/2024 passed by the learned member MSCT number 3 Kamruk M in MSC case number 941 of 2017. File under section 166 of the ME Act. It is to be noted here that by the impugned judgment and award dated so the learned tribunal has directed the appellant herein a sum of rupees
21 lakh.
20.
21 lakhs 55,887.
Page number?
This is page number 36 of the 36. Memo. ₹21,55,887 with interest at a rate of 9% per annum.
Where is the memo of appeal and the grounds mentioned therein? Admit, issue notice to the respondent, returnable in 4 weeks. Step upon respondent number 2 and 3 be taken by registered post with AD and also by usual process.
I'm not pressing the stay petition now. Lord.
Okay. However, no formal notice is required to be issued to the respondent number 1 since so and so entered appearance and received notice. However, extra requisite copy of the petition be furnished to them during the course of furnished to her during the course of the day. So we'll refer the matter to look at a look.
Yes, Lordship. We have in fact both submitted the slips, but it
Okay.
is yet to be listed.
It is submitted at the bar that the parties are willing to settle the matter in the coming look at the lot to be held on 14.
14.
And as such, the rest may be directed to list the matter before the ensuing look at the lot. There is accordingly allowed. Rest is directed to list the matter before the ensuing.
Obliged, Lordship, deeply obliged.
17.
For enhancement, notice me caller.
Death case or injury case?
Death, Lordship.
Injury.
Death.
Heard Mr. M. Khan learned counsel for the appellant. This appeal under section 173 and the act is directed against the judgment and award dated 20th March 2025. Passed by the learned member, motor accident claim tribunal. Boygo. In MSc appeal number 327 of 2020. This to be noted by the impugn judgment and award dated so and so. The learned tribunal has directed the respondent Oriental Insurance Company Limited to pay a sum of rupees 7,65,700 being the compensation to the appellant hearing. Here is the memo of appeal and the grounds mentioned therein. Admit issue notice to the respondent. Returnable and for it, step be taken by registered post with AD and also by the process. This is the matter of the correction.
I'll put record, please.
Record. This is a call for the record. The learned tribunal.
Item 18.
Obliged.
My lord, we are preparing the appeal on the ground, my lord, there is no loss of dependency, my lord. Because the deceased was the, my lord, government employee, my lord. And according to Assam government notification, my lord, they were getting a full pension, my lord, family pension, my lord.
Okay.
The present case may be stayed, considering there are some medical expenses and conventional health may be related.
Is there any step it is?
Stay, yes, my lord, we have kindly allow them 20%, my lord. Stay. And
You will pay
conventional
20%.
head, my lord. They were they may get only 20%, my lord.
The total award.
Total award. Of the total award, my lord.
As medical expense, we are ready with 20.
No problem.
Heard Miss L. Sharma, learned counsel for the appellant, and also heard Mr.
A and equal for respondent number 1, 2, 3, and 4.
Respondent number 1, 2, 3, and 4. Its appeal under section 173 of the Act is directed against the judgment and award dated 23rd April 2025. Passed by the learned member, MSc number 1, Kamrup M. Guwahati in MSc case number 193 of 2021. It is to be noted here that by the judgment and award dated so and so, the learned tribunal has directed to pay a sum of 87,54,517 rupees with interest at the rate of 6% per annum from the date of filing the claim petition till final payment. Where is the memo of appeal and the grounds mentioned here? admit issue notice to the respondents, returnable and for it. Step be taken by registered post with heavy and variable process.
5 and 6.
Within a week from today, upon respondent number
5 and 6.
5 and 6.
Yes.
However, no formal notice is required to be issued to the respondent number 1 to 4. Since Mr. Iqbal entered appearance and received notice. However, extra requisite copy of the memo of appeal be furnished to him during the course of the day. With the matter of 4 weeks. IA subject to default of 20%.
That may be released. That may be.
Is allowed to withdraw the same. Yes.
Obliged, my lord.
19.
May it please your lordship. Lordship, this appeal is on quantum lordship. This appeal may be admitted and my additional prayer is that my lord that case may be posted before Lok Adalat. We have already
Compromised the case.
Heard Mr. T. Coletta, learned counsel for the appellant, and Mr. Iqbal for respondent number
Respondent number
125. 125.
1, 2, 3, 4, and 5.
1, 2, 3, 4, and 5.
Your lordship, however, respondent number 4 and 5 have expired. The judgment has been reflected. It could be respondent number 1, 2, and
If we were going to settle the matter in the local law, this appeal under section 173 of the MP Act is directed against the judgment and award dated 3rd of March 2025, caused by the learned member, motor accident claim tribunal number 1, Kamrup M. and Guwahati, case 15. Where is the memo of appeal and the ground? It is to be noted here that by impugned judgment and award dated to the learned tribunal has directed the appellant herein to pay a sum of rupees. What is that quantum?
Lordship, 39 lakhs 53,055 rupees.
39 lakhs
Page number 24.
55 rupees. Being the compensation, the respondent number 1 to 5.
1 to 5.
1 to 5. Where is the memo of appeal and the grounds mentioned there? Admit. Issue notice.
Okay.
However, no formal notice is required to be issued to the respondent. 5 since Mr. entered appearance and received. If upon respondent number 6 and 7 be taken by registered post with daily and also by usual process. It is submitted at the bar that both the parties are negotiating to settle the matter amicably. And as such, the matter may be listed before the Lok Adalat to be held on 14th of June 2025. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recess and leads the matter for the Lok Adalat.
Much.
Good.
Steps of what
May I please, your lordship? Your lordship, as per the instruction that we have received, the officials of the department,
I have the instruction to withdraw lordship petition.
Okay. Mr.
Yes, Ali.
As only learned counsel for the accused submits that he has the instruction to withdraw this petition. Accordingly, this bail application number so and so is as a disposal of withdrawal.
Seconds for hearing order 41. Item 21.
Yes.
May it please, your lordship. This second appeal has been preferred by the defendant's lordship. The suit was for right title interest and eviction of the defendant's lordship. Page 15 of the prayer of the plaintiff's lordship.
that a decree be passed declaring that the plaintiff has right title and interest over the suit land and that the defendants have no right title and interest in any manner whatsoever upon the suit land, that the possession of the plaintiff over the suit land be confirmed, and if during the pendency of the suit the defendant consolidate their possession and start residing in the suit land, a decree be passed for recovery of khas possession of the suit land by evicting the defendants together with demolition of the structures raised by the defendants therefrom, and the permanent injunction be issued against the defendants restraining the defendant. So these are the prayers of the plaintiff lordship. Thereafter, we have contested the case. Our written statement annexure to page 19. Our case is that lordship, we are the three defendants. We have purchased 3 plots of land together, and thereby we are residing over the suit land by dint of purchase, lordship. But the learned trial court held page 34, your lordship will find that while deciding the issue that whether defendants are trespassed to the suit land.
So, your case is that you have purchased the said plot of land
Yes, lordship.
by registered sale deed?
Yes, lordship. So we are able to prove our case. So learned trial court dismissed the suit of the plaintiff, lordship. Page 38. Plaintiff suit is dismissed on contest with cost. Page 38, lordship. As because lordship plaintiff, while adducing evidence, he himself admitted that he stated that the defendants are possessing their respective plots of land which they purchased from the date of purchase, lordship. It is reflected in the trial court judgment, lordship.
Pardon?
Plaintiff PW1 admitted that the defendants are possessing their lands after purchase since the date of their purchase. So trial court held that when plaintiff himself admitted that defendants are not illegally possessing the suit lands, so how it is illegal possession by the defendants? Page 34, your lordship will find. While deciding issue number 6, whether the defendants are trespassed to the suit land and liable to be evicted from the same.
While deciding issue number
6, lordship. There are 3 issues decided together, lordship. Issue 4, 5, and 6. The evidence of PW1 was discussed by the learned trial court, lordship.
And what is the finding of the trial court upon these 3 issues?
Lordship, plaintiff failed to prove his case, lordship. Page 35, your lordship will find between the entire paragraph, he also admitted that portion, lordship. PW1, he also admitted that the purchaser, that is defendant number 1, 2, and 3, is in possession of the land by purchasing the land from pro forma defendant number 5 since 1991 to 1995. So after discussing this, the trial court held that plaintiff failed to prove his case. If your lordship allows, I can read the entire.
Not necessary. Thereafter, what happened?
Thereafter, lordship, the plaintiff preferred title appeal that was decided by the learned first appellate court against the defendants. Page 46 is the judgment of the learned first appellate court. Page 60, your lordship will find relevant paragraph 26. So it is an admitted position that the defendant number 1, 2, and 3 are possessing the suit land, that is the Schedule C land. Now it is to be seen that whether the said possession of the suit land by the defendant is genuine or is an encroachment. Now the defendant's claim of genuinely purchasing the suit land, the DW1 Himanshu Das, who is the defendant number 2, has stated in his evidence that the defendant number 1, 2, 3 had purchased the scheduled land from Gajendra Kumar Borua. Now the DW1 has exhibited the certified copies of the registered sale deed so and so, by which pro forma defendant number Amalendu Borua sold Gajen Das a plot of land measuring 1 bigha as Exhibit A. In this case, what happened, Lordship? This Amalendu Borua had land, Lordship, almost 39 bighas, Lordship. So he sold some land to different persons, including plaintiff and defendants. Plaintiff is not aware about his own land. He is claiming that I am not sure who is occupying my land, but I have purchased. And in other sense, he is saying that defendants are occupying their purchased land since the year 1991 and 92. So the learned trial court held that plaintiff himself is not aware which land is occupied by the defendants and what is his purchased land. So suit was dismissed. But the learned trial court held burden shifted to the defendants and said that they failed to produce the sale deeds while certified copies were produced. On all these, Lordship, the suit was decreed by the learned first appellate court. So I have cited the grounds also, and thereafter some substantial question of law, page 6, Lordship. Entire trial court judgment, Lordship, only on the basis of presumption, when it is the settled position of law that plaintiff has to prove his own case, Lordship. Merely saying that we are possessing the suit lands, Lordship, without exhibiting the original sale deeds, when it is, in fact, Lordship, proof that we are possessing the lands since 1991 when we purchased the land. And it is plaintiff he himself admitted.
But this question, can it be said to be substantial question of law?
Yes, Lordship, the substantial question number 3, that is a legal position, Lordship, whether plaintiff has able to prove his case. When trial court finding is very clear, Lordship, plaintiff in his evidence, in his pleading, in plaint also, Lordship, he has made defendants 2 times, one pro forma defendant and again main defendant. And in the pleading, he written that I am not sure whether they are occupying my land or not. So I have made them pro forma defendant as well as main defendant.
Not to decide this question, so this court has to embark upon the facts.
It's a decree of
Whether
reversal,
whether the second appellate court is entitled to appreciate the fact.
No, Lordship, this is a question of law. Plaintiff has to prove his own case. The burden cannot be shifted to defendant, Lordship, to disprove the case of the plaintiff, Lordship. First, plaintiff has to prove, then only burden on us will shift to the defendants, Lordship. But the learned first appellate court discussing the case of the defendants decided the suit. And it's a case of reversal, your Lordship.
Pardon?
This is a case of reversal, Lordship. Trial court dismissed and first appellate court decided that, decreed the suit.
Okay. Part Ms. R. Chaudhary, learned counsel for the appellate. Order reserved. We'll say, we'll examine.
Lordship, in other 2 items, Lordship, today I could not prepare as because there is another matter in court 40 notes.
On the pair being made by Ms. R. Chaudhary, learned counsel for the
22 and 23.
Lordship. List the matter. After
1 week, Lordship.
After 1 week.
And Lordship, in this case, I have filed IA also, adducing the.
We'll say if we admit the appeal, then definitely we will take a call upon the IA.
25.
May I please, Your Lordship?
Yes.
My lord, this second appeal has been filed by the plaintiff by the plaintiff who filed a suit for declaration of right title interest and the recovery of possession. Recovery of possession. The case is this, my lord. The plaintiff and the pro forma defendants are the owner. They are the sons of Bapuram suit, Bapuram Bora, plaintiff and pro forma defendants. The plaintiff filed a suit for declaration of right title interest of the suit land along with the pro forma defendants. And the defendant, your lordship, kindly see the plaint, my lord. Plaint one is page 10.
Yes.
Page 10, declaration that the joint right, title and interest of the plaintiff along with the pro forma defendants. Recovery of cash possession by ejecting the dependent, their manager, permanent ejection. The Bapuram suit is the original owner of the land, and after his death, the plaintiff and the pro forma defendants became the owner of the land. The defendant, he has no title over the land, illegally occupied our land, and on our request, he refused to vacate the land. Thereafter, we filed a suit. And thereafter, a survey commission was appointed. Survey was done, found that he is in illegal occupation of our land. The survey officer put the fencing on the, put the pegs on the boundary. After left the survey officer, the defendant removed the said post and illegally. Thereafter, I filed the suit. The suit was contested by the defendant. His one ground is this: the prayer in the written statement. The suit is bad for non-joinder of necessary parties, and it is at page 13.
So this issue is decided against you.
Yes, yes. Non-joinder decided against me. My lord, I want to say that both the courts below wrongly decided that the suit is non-joinder of necessary parties, because it is not a suit for partition. It is a suit between the owner of the land and the trespasser. I am not praying for partition of the land. The trial court held that as the word Makiram suit was not made party, he was a partner, he was not party, therefore suit is bad for non-joinder party. With Makiram suit, I have no connection. I am only connected to the defendant Surenbora. Surenbora occupied my land. And I filed the suit for declaration of title and recovery of possession. It is not a suit for a partition. Therefore, all the partners are not required to be implicated in this suit. The trial court held that as Magiram suit was not implicated in the suit, therefore the suit is bad for non-joinder of necessary party. Deposition to form. And my lord, I have gone through the deposition of the defendant in his deposition stated like this, my lord. I am just read one line. মোৰ শপতনামাৰ গোটেইখন মোৰ জ্ঞাত মতে কোৱা লিখা হৈছে। মোৰ দেউতাৰ নামটো বাপুৰাম। মোৰ দেউতাৰ বাদীৰ দেউতাকৰ নাম বাপুৰাম, তেখেত ঢুকাল। মাঘিৰাম চুদ বহুত বছৰ আগতেই ঢুকাল, তেখেত অবিবাহিত আছিল। If he is unmarried, then how he can be implicated? And what is the necessary for implicating the Makiram? Because I am not filing the suit for partition. Therefore, the issue number 5, issue number 3, whether the suit is liable to be dismissed for non-joinder of necessary parties, it is absolutely incorrect. And my lord, your lordship kindly see page number 34, issue number 5. This is issue number 5, page 34. Considering the decision on issue number 4, the plaintiff and the pro forma defendants have right, title, and interest over the suit land. The plaintiff alleged that the defendant have dispossessed the plaintiff in the suit land. The defendant depend upon the same as defendant stated that the father of the defendant during the lifetime occupied the shared land belonging to the co-partner Magiram Sud about 50 years ago by cultivating and planting trees. That, that after the death of the defendant continued their possession over his land belonging to the Magiram Sud under tag number 7. In the case, it is seen that although the defendant denied the disposition of the plaintiff, and from the same they have admitted they are possessing the share of the land of the Patadar Magiram Sud, which fall under tag number 207. Exhibit 1, it can be seen that the defendants nor the father of the defendants mutated their name. And they have admitted that the father of the defendant, father and after his death themselves have been possessing the share as a co-partner of Magiram Sud, which falls under tag number 207. Hence, without any lawful right of the defendant being possessing the suit falling under tag number 207, as such, it can be held that the defendants are the trespasser over the suit land. Trial court held that the defendants are the trespasser. If defendant are the trespasser and defendant claim he is the heirs of Magiram, and Magiram he in the deposition stated that Magiram died unmarried. Both the trial court and appellate court held that the suit is bad for non-joinder of necessary parties. It is absolutely perverse finding, and it should be decided, and thereby non-joinder thereby issue number 4, my right title interest over the land has been has not been granted. The substantial question of law, your lordship, by issue number 3, substantial at page 4, whether the court below misinterpreted Order 1, Rule 9 of the Code of Civil Procedure, thereby holding that the suit is barred by the principle of non-joinder of necessary party. Inasmuch as defendant in the cross-examination admitted that Magiram Sud died unmarried.
So whether this first substantial question of law is required to be framed. Because in the second substantial question of law also you have taken the same down perversity.
Yes. My lord, the only, your lordship can frame the ground number 3.
Three.
3. Because if my suit is, appeal is allowed, then the non-joinder will go, then I will get the possession bill. Only at this point, my appeal has been dismissed. So I am the owner of the land. And he said that the Maghiram was there, not empty. And Maghiram suit has not, because it is not a suit for partition. All partners are not required to be party.
But Mr. S. Sharma, learned senior counsel assisted by Mr. G. Vardas, learned talent. This appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated 18/3/2025 passed by the learned civil judge senior division Gulaghar in title appeal number 7 of 2021. This to be noted here that by the judgment and order date, judgment and decree dated 18/3/2025, the learned civil judge senior division Gulaghar, herein after first appellate court has affirmed the judgment and decree passed by the learned Munship number 1 Gulaghar in title suit number 8 of 2014 by on 5/4/2021. Further, it is to be noted here that by judgment and decree dated 5/4/2021, the learned Munship has dismissed the suit of the plaintiff. The appellant hearing. Where is the memo of appeal and the suggested substantial question of law, and also where is the judgment and decree dated 18/3/2025 passed by the learned civil judge senior division Gulaghar, and also the judgment and decree dated 5/4/2021 passed by the learned Munship number 1 Gulaghar entitled to number 8 of 2014. This second appeal is admitted on the following substantial question of law. Whether the learned courts below misinterpreted order 1, rule 9 of the Code of Civil Procedure in holding that the suit of the plaintiff is barred by the principle of non-joinder of necessary party, inasmuch as the defendant in cross-examination admitted that Mohiram suit died unmarried. The court may also consider framing of further substantial question of law if found necessary at the time of hearing, giving notice to both the parties. Issue notice, returnable after 4 weeks, step be taken by registered post with KD and also the process. We confident. SSL call for the record of the learned courts below. Please the matter after 4 weeks.
I live like.
Item number 26.
My lord. My lord, the first appellate court has dismissed the appeal on the point of limitation, my lord. That is the only point to be considered.
Pardon? Pardon?
First appellate court has dismissed the appeal on the point of limitation laws.
On the point of
Limitation.
limitation.
So that is the only point to be decided by this honorable court whether when the merit is required to be examined, whether the learned first appellate court or appellate court can I've already formulated a substantial question of law also. Whether the learned first appellate court is correct in dismissing the first appeal being so and so on the
What
point
is
of
the
delay.
period of delays?
Period of delay is 1 year, 20 days. Not. We have substantiated the same by of sufficient medical documents. And
Let notice go at this.
Lordship, I'm relying on a Supreme Court judgment, Lordship, because on this point,
Or Mr. D does Lordet. Counsel for the appellant. The appeal under section 100 of the Code of Civil Procedure is directed against the order dated 4/6/2024 passed by the learned civil judge, senior division Barpeta, in Meiji case number 176 of 2023.
Yes.
Arising out of title appeal number 37 of 2023. Wherein the learned appellate court has rejected the prayer made by the petitioner for condemnation of delay of 1 year 20 days before title appeal number 30. There is the memo of appeal and announcements of here. To peruse the order dated 4/6/2024 passed in case number 176. Arising out of title appeal number 37.
Lordship, in this case, the learned trial court has totally ignored the fingerprint opinion report, Lordship. That was
ignored the
fingerprint opinion report, Lordship. And the plaintiff, the present respondent is the plaintiff in the original suit, Lordship. At the instance of the plaintiff, the cell deed in question, it was sent for expert opinion for fingerprint opinion. So after receiving that sample was taken, the opinion was also forwarded to the learned trial court. But subsequently, that was not considered, Lordship. In the fingerprint opinion report, I have annexed the fingerprint opinion report, Lordship, at page 90.
The question is how you have explained 1 year 20 days before the learned
that has been, but
appellate court. That is the question.
That the thing is that, Lordship, in the Supreme Court judgment, Lordship, which is reported in 2025 INSC 382, it has been held by the Honorable Supreme Court that if in a particular case marriage have to be examined, it should not be scaled merely on the basis of limitation, Lordship. This point has been decided by the Honorable Supreme Court, Lordship. So in the original suit, Lordship, the original suit fingerprint opinion has been ignored, and that was not also considered by the learned appellate court, simply going into the limitation point of limitation, Lordship, whether the first appellate court ignored the merit of the case, Lordship, where there is a scope of examining the same, Lordship. Because it is not in dispute that the present appellant, they are in possession, Lordship. Only the point of contention that has been raised by the plaintiff was the cell deed, Lordship. And cell deed was sent for expert opinion at their instance.
Considered at the time of hearing.
No, Lordship, this is the point of law, Lordship. Whether if there is merit is to be examined, whether it should not be if in a particular case merits have to be examined, it should not be scalded merely on the basis of limitation.
That will be considered at the time of hearing.
No, Lordship, this is the only consideration before your Lordship.
This second appeal is admitted on the following substantial evidence. Whether the new order dated
4/6/2024
4/6/2024 passed by the learned Civil the Senior Division Barpeta in Meche case number 176 of 2023. Suffers from perversity or non-appreciation of the merit of the case.
Yes.
Issue notice to the respondent, returnable in 4 weeks, that be taken by registered post with AD and also by the prosecutor. Recessal call for the record. Please the matter after 4 weeks.
Lordship. So I have an IA lordship. As on today, we are in possession of the suit land lordship, with the B schedule land of the plate lordship. And the title execution case is also pending lordship, which is fixed tomorrow lordship. So status quo as on today, along with the stay of the title execution case may be stayed lordship. The status parties may be directed to mandate.
Applicant is interlocutory application under order 39 group 1 and 2. Read with section 151 of the Code of Civil Procedure is referred by the applicant for grant of temporary injunction, restraining the opposing parties from plaintiffs and their present and workmen from occupying the suit land or doing any cultivation and stroke or construction work in the suit land and stroke or alienating the same to any other party by way of sale, mortgage, etc. till disposal of the connected second. Sir, does learned counsel for the applicant submits that the second appeal has already been admitted by this court, that the record has also been called for, and that the suit land is still under the occupation of the present applicant. And the respondent herein have already instituted on title execution case.
At page number 12 lordship, the order.
The big title execution case number 8 of 2023. And the learned executing court has fixed the matter on tomorrow. So, though the case is fixed on tomorrow, yet the writ has not yet been issued. It is kept tag with the record.
Yes, lordship. But if there is no stay order lordship, there is possibility of issuing the writ lordship. And as your lordship has already admitted the appeal, so
But it has been kept on record on the objection raised by decree holder. Taking note of the submission of learned counsel for the applicant and also considering the fact that the applicants are still under probation of the suit plan. This court is inclined to direct the parties to maintain status quo as on today
lordship.
till a returnable date.
And lordship, the further proceeding of the execution case may also be stayed lordship.
Pardon?
Further proceeding of the execution case may also be stayed lordship.
No, we have already directed to maintain status quo. Is there any necessary to?
Lordship, lordship, kindly indicate it lordship.
Next step.
Lordship.
27.
Lordship, I take fresh steps against the owner lordship. Owner is not answered notice return. No Vishnu plate number.
Oh, you obtained the complete address of the respondent number 3 and take press step. The remark is that it returned with incomplete address.
Lordship.
Third, Mr. Ahmed learned for the appellant and Madam Chaudhary for respondent number
One, Lordship.
1 and
Only one, Lordship.
1.
Yes, Oriental Insurance Company Limited.
Respondent number 2 notice served.
Notice, Lordship, notice, I think, yes.
Notice. Private solicitor.
Pay to serve. Office note dated 10/6/2025 indicates that notice issued to the respondent number 3 returned with a report. Returned with a postal remark with an inverted comma incomplete address. Accordingly, it is provided that Mr. Ahmed shall obtain necessary inspection and take press slip upon respondent number within a period of 1 week from today by registered post with AD and also by usual process. This is the matter after 4 weeks.
28.
May I please, Lordship? Lordship, kindly peruse office note dated 11/6/25, my lord. Respondent number 1 and 6 already appeared, my lord. And 2 and 3, my lord, cannot serve, my lord, because my lord, respondent number 2 left the place and respondent number 3, my lord, not found, my lord. And respondent number 4, my lord, received by wife. And respondent number 5, my lord, expired, so he on his behalf, his son accept the notice, my lord. And 6, they are appearing, my lord.
I am appearing for respondent number 6.
6.
Yes, Your Lord.
So, my lord, we have again take steps on respondent number 2 and 3, my lord. And 5 is accepted by on behalf of his father, my lord. So it's up to you, my lord. You can substitute or they may file wakalnama, my lord.
Third means also a Lord at for the this for the respondent number 6 and you for
Respondent number 1.
Respondent number
1, my lord.
1. Respondent number 1. Office note dated 11/6/2025 indicates that notice issued to respondent number 2, 3, and 4. 2 and 3 returned with a report that the addressee could not be found. The notice issued to the respondent number 4.
2 and 3, my lord.
Was received by his wife and respondent number 4 suffered demise.
Respondent number 5, my lord.
Respondent number 4 suffered demise. Accordingly, it is provided that the learned counsel for the appellant shall take press slip upon respondent number 2 and 3. And also take necessary step for implementing the legal representative of the respondent number 5. Step upon the respondent number 2 and 3 be taken by registered post with AD and also by the process. This is the matter after 4 weeks.
Obliged, my lord.
29.
May I please your lordship. As per last order and this honorable court last order dated 30/4/2025, we have taken steps by publication of notice in the newspaper. We have also filed the affidavit yesterday, Lordship. I think that affidavit is not in the record, Lordship.
In respect of service of notice upon respondent number
5 and 6, Lordship.
5 and 6. It was effected by Dusty Mode,
No paper publication.
paper,
Paper.
heard Mr.
NM Dr. Lordship.
NM Dotto, learned from the appellant and Miss.
My lord, I'm appeared by Mr. B. Prasad. I'm here to
Your name,
respond
please.
number 1, 2, 3, and 4.
Your name,
Leena Das.
neither does learned counsel appearing on behalf of Mr.
Mr. B. Prasad.
P. Prasad, learned counsel for the respondent number 1, 2, 3,
3 and
and 4.
4.
The learned counsel for the appellant submits that he has effected service upon respondent number 5 and 6 by way of paper publication. And he has filed an affidavit to that effect yesterday.
Yes, that Lordship.
Yesterday, but the same has not been placed on record. Accordingly, it is provided that recital lays the matter on it. Twenty-fifth,
Lord.
25th. An intermediate recital place on record the affidavit filed by the learned.
Obliged.
30.
May it please your lordship. Lordship, we were instructed to take steps upon respondent number 1, 2, and 3 by newspaper. However, lordship, we could not take the steps on time, lordship. So one opportunity may be granted to take fresh step upon.
The formal learned counsel for the applicant submits that. Though he was directed to take step upon respondent number 123 by substituted mode, yet he could not take step. And he pressed for granting him another opportunity. There is accordingly allowed. List the matter after 2 weeks.
Newspaper publication, lordship, so a date may also be fixed. Date of appearance.
Okay. When can it be fixed?
After the vacation, 28
July.
Obliged.
31.
Right, Pujara. Hello, this is application for restoration of a civil revision petition, which was dismissed for default. And since an objection has been raised on behalf of the other side, that the provisions of Order 9, Rule 9, or any other provision in the Civil Procedure Code providing for restoration of a suit or appeal will not be applicable in this case because it is a revision. And that is the objection. And as far as facts are concerned, my learned friend has already submitted. It's a case under the Assam Urbanist Rent Control Act. Suit was decreed against the applicant before lordship, who was a tenant, on the ground of defaulter as well as bona fide requirement. On appeal, my lord, the defaulter ground has been reversed. The finding has been reversed. And so far as bona fide requirement is concerned, that has been upheld. So the revision petition will be heard on the question of the validity of the finding, on the question as to whether the landlord has been able to prove that his premises are required bona fide or not. So that is on merit, my lord. So far as the present IA is concerned, my lord, since miss case, it was earlier registered in 2024 when this IA system was not there. It was miss case 67 of 2024, my lord. And the facts are very clear, and as your lordship has seen, and possibly I should address only on the question of the applicability of Order 9, Rule 9, or any other provision if available in the Civil Procedure Code for restoration of the civil division petition, which was recent for default. Well, I'll be relying on 2-3 judgments. Lordship will kindly consider that. And my submissions basically will be like this manner. Yes, it is correct that specifically Civil Procedure Code doesn't say about restoration, or in Order 9, Rule 9, there is no specific mention of a revision petition. But then the courts were faced with this kind of situation, and it was held that, first of all, there are two lines of my lord thinking. One is under Section 151, by invoking the inherent jurisdiction of the Supreme Court, court can restore. And the other line is, my lord, provisions of Civil Procedure Code and Order 9, Rule 9 will be applicable in view of Section 141 of the Civil Procedure Code. This is my
141.
my lord. Lordship has got my 141 miscellaneous proceedings. The procedure provided in this code in regard to suit shall be followed as far as it can be made applicable in all proceedings in any court of civil jurisdiction. Then there is an explanation, my lord, which was inserted subsequently in 1977 amendment. In this section, the expression proceedings includes proceedings under Order 9. We are concerned with applicability of Order 9 here, madam. Order 9, but does not include any proceeding under Article 226 of the Constitution. So, madam, in view of Section 141 of the Civil Procedure Code, all the provisions of Civil Procedure Code will be applicable in any proceeding which is civil in nature, and civil revision petition is definitely, my lord, as civil proceeding. And I'll be relying on a few judgments in support of this contention. And my third submission will be, in my lord, Assam, my lord, in view of Section 8 of the Assam Urban Restraint Control Act, only one appeal is provided against a decree passed in an ejectment suit under the Assam Urban Restraint Control Act. Thereafter, my lord, Section 8, my lord. And thereafter, my lord, no second appeal is permissible. And that is why we file a revision under Section 115 of the Civil Procedure Code, my lord. And this is, although a revision, since there is a relationship of inferior court and superior court, and the entire decree passed by the first appellate court remains under challenge and remains open for scrutiny by the High Court. This revision is actually an appeal. It is almost like an appeal, and I'll be relying on a specific judgment on this issue. There is a judgment of our High Court. It came up in a case where an argument was placed that this provisions of Order 22 providing for substitution of legal heirs is not applicable in a civil revision, because there also civil revision petition is not mentioned in Order 22. That question came up in 2016. There is a judgment. I'll be relying on that also. That is my third argument. First is, my lord, lordship can invoke Section 151, that is the inherent jurisdiction, to, my lord, undo what has been done. Because if there is no provision for dismissing a revision petition for default, then matter would have been different. There is no provision for dismissing a revision petition for default. At the same time, the Supreme Court dismisses it. Where is the remedy? So my first submission is, under 151, lordship can invoke inherent jurisdiction to restore it. Secondly, in terms of Section 141, since it is a civil proceeding, Order 9, Rule 9 will be applicable. And thirdly, this revision petition is actually like an appeal, and that being the provision, the Order 9, Rule 9 will be applicable even in that circumstance. These are the three submissions. Well, the first judgment on which I am placing reliance is This is a judgment passed by Jammu and Kashmir, my lord, High Court. It is reported in 2003 supplementary JKJ 354, my lord. Lordship, I am reading paragraph 1 first, my lord. Through the medium of petition in hand, the petitioner, namely so-and-so, has sought indulgence of this court for restoration of civil division number so-and-so, dismissed by this court on so-and-so for non-appearance of the petitioner. It is entirely maintained that the petitioner filed a revision petition against the order dated so-and-so passed by Additional District Judge Srinagar. That in so-and-so, this court came to issue notice in the said revision petition, which was accepted by Mr. So-and-so, advocate on behalf of the respondent, and the case came to be adjourned for service of notice on the remaining respondents. That after so-and-so, the petition was listed in the court on 11/2001, when the lawyers were on strike, as a result of which the petitioner bona fide believed that since the lawyers are on strike, the court would adjourn the case, but on the same day, so-and-so counsel appeared for the respondents, and this court heard the matter on part and directed the matter to come up next week. The matter was listed before the court on 25/4/2001, when again the lawyers were on strike. Since the petitioner has not caused his appearance on so-and-so before the court, as the bona fidely believed that the court may have adjourned the case on its own, therefore on 25/4/2001 also, he did not cause his appearance. On this day, the counsel for the respondents appeared and the case was dismissed for want of prosecution. That in the revision petition, an important question of law was raised which need authoritative pronouncement. Therefore, the same could not have been dismissed in default. Then we go to paragraph 4, manner. The submission of Mr. So-and-so that the provisions of CPC cannot be made applicable to the petition in hand, which ostensibly is filed under Order 9, Rule 9 CPC. In this behalf, he has invited the attention of this court to Section 19 of the Arbitration and Conciliation Act 1996, which deals for determination of rules of procedure in the conduct of arbitration proceedings, therefore, cannot be made applicable to the case in hand. These being so, the submission is not tenable. Section 141 of the Civil Procedure Code provides that procedure provides in this code should be provided in this code in regard to suits shall be followed as far as it can be made applicable in all proceedings in a court of civil nature, civil jurisdiction. The explanation to this section provides that the expression proceedings in this section includes proceedings under Order 9, but does not include any Article 226 of the Constitution of India. In the case of Munshi Ram versus Banwarilal, AIR 62, Supreme Court 903, the Lordships of the Supreme Court have held that under Section 141 of the Arbitration Act and also under Section 141 of the CPC, it was competent to the court before which award was made by the arbitration tribunal has filed for passing a decree in terms of thereof to permit parties to compromise under Order 23, Rule 23 CPC. In view of the authoritative judgment of the apex court, the Code of Civil Procedure Code is applicable to the proceedings in court under Arbitration Act as also to the petitions for restoration of such proceedings under Order 9, Rule 9 CPC. This takes us to determine as to whether the on so-and-so when the civil division in question came to be dismissed, whether the petitioner had sufficient cause for his non-appearance. Then down below, my lord, in the same paragraph, 5th line from bottom, therefore, Lordship has got, my lord, therefore, the petition is allowed and the order impugned recorded on so-and-so with respect to civil division is set aside, subject to payment of cost of the so-and-so payable within 4 weeks from today, and the petitioner is permitted to recover half of the cost, etc. So, in terms of Section 141, Order 9, Rule 9, CPC was held to be applicable for restoration of a civil division. This means for default. The second judgment on which I am placing reliance is, my lord, is again of Jammu and Kashmir, decided on 30th of December 1999, Raja Bibi versus Sabur Wani. This is reported in AIR, my lord, AIR 2000, Jammu and Kashmir, page 83. small judgment, my lord, small paragraphs. I'm reading from para 1. My lord. The motion is laid on 30th of April 1998 for restoration of civil division number so titled Musammat Raja BB versus Sahur Wani and others, dismissed on 1/4/1998 for non-appearance and in default of prosecution. As some doubt crept whether a civil division dismissed for absence without hearing can be restored. Mr. So was heard on this. The learned counsel submits that revision is against order dated so of Munsif upheld in appeal number so by the district judge. These orders are handed down in civil original jurisdiction suit for declaration, partition, and injunction on so. Revision against the order is filed under section 115 of the CPC. Therefore, the revision is in fact a continuation of the original proceedings, and a restoration of dismissal of the revision is covered by enabling provisions of Civil Procedure Code. On examination of the matter, provisions of section 141 CPC germane to the controversy in question is required to be taken note of as under. That is quoted, my lord. Next paragraph. The words all proceedings are wide enough to include revision. In 1901 Punjab record, page number so the learned judges held that an application for restoration of revision would lie when the original application is dismissed for default, but no second application would lie if the first revision application has been decided even ex parte. In AIR 53 MB 272, the provisions of Order 22 Rule 9 of CPC have been applied to revisional proceedings after placing reliance on section 141 of CPC. In AIR 1966, JNK, a learned single judge of this court, has held that section 141 of CPC does apply to revision petition. The term all proceedings in section 141 CPC is in aid of court so as to include proceedings of civil nature, original as well as others which cannot be termed as original. The word all is comprehensive term, and obviously revision is covered by phraseology of section 141 CPC. Another decision of this court reported as so as also is relevant for the proposition that revision petition dismissed for absence can be restored by resorting to section 141 CPC. In Jawahar Prasad so AIR 83 Supreme Court on so, neither party was present at the time when the revision of application was called on for hearing by second petition district judge. The revision was dismissed. An application moved for restoration of the revision petition was taken up in so, but was again dismissed without opportunity of being heard to the concerned party. In revision, High Court at Allahabad upheld these orders. The Supreme Court allowed the appeal after setting aside the order of second additional district judge dated so and ordered so of Allahabad High Court, and the revision application was restored to its original. In the result, application for restoration of the dismissed revision application in the facts and circumstances of the case is held maintainable. Then on section 151, I'm relying on a judgment of Nagpur High Court. It's a division bench judgment final. Dhondiba Appa Saheb versus Vasudev Anand Sherlekar.
Is it necessary to multiply the decision?
My lord, it is not necessary, but this judgment will be possibly necessary here. Section 151 was invoked, and the Honorable Court said that under section 151 we can exercise the inherent jurisdiction to restore.
No. Regarding the inherent jurisdiction, is there any controversy? No controversy.
There is no controversy.
Then,
and what I am submitting is,
now you tell me strictly which provision can be applied, 141 or 151?
My lord, my submission, I'll leave it to your lordship, my lord. In either your lordship invokes section 151, the inherent jurisdiction of this Honorable Court, because in this judgment also it has said that ex debitio justitiae be restored under section 151. So to do justice, my lord, lordship can either invoke section 151 or in terms of section 141, lordship can say that all other provisions of the Civil Procedure Code is applicable in a revision petition. So Order 9, Rule 9 is also applicable, as has been held by this two courts that I have cited. And this judgment on which I am now placing reliance, it has dealt with the specific objection that in this Order 9, Rule 9 and Order 41, Rule 19 of the Civil Procedure Code doesn't apply to a revision petition. In spite of that, my lord, 151 was applied and said that it can be restored. And my lord, one judgment will be of some importance, my lord, in view of the objection raised. This is a judgment of our High Court, reported in 2016 4 GLT, page 383, man.
Which provision was applied there?
Here, my lord, 141 was dealt with, and specifically, it has been relying on the 71 Supreme Court judgment, my lord, that although it's a revision, but it is an appeal in fact, and therefore the provisions of Civil Procedure Code will be applicable.
What is the observation of the Supreme Court?
My lord, Lordship may straightway come to page 7, my lord, maybe first, second, third, fourth page, my lord. Page instance is now there. Paragraph 7. Lordship has got, my lord.
Yeah.
Subsequently, in the case of Shankar Ramachandra Abhayankar versus Krishnaji Dattaray Bapat, reported in AIR 1970 Supreme Court, page 1, the question came up before the Honorable Supreme Court as to the nature and character of a revision petition. The Honorable Supreme Court considered the aforesaid judgment of the Honorable Privy Council in the case of Nagendranath De versus Suresh Chandra De, and having made elaborate analysis, held the view that a civil revision is only a form of appeal. Even in the principle of merger of orders of inferior courts would not become affected or inapplicable by making any distinction between a petition of a revision or an appeal. Section 115 of the Civil Procedure Code circumscribes only the limit of appellate jurisdiction, but the jurisdiction which is being exercised is a part of the general appellate jurisdiction of the High Court as a superior court. It is only one of the modes of exercising power conferred by the statute, and basically and fundamentally, it is appellate jurisdiction of the High Court which is being invoked and exercised in a wider and larger sense. With these observations, the Honorable Supreme Court equated a revision petition with an appeal. And here, my lord, examples were also given that a revision petition filed under against a decree passed in an ejectment suit under Arbitration and Rent Control Act, which your lordship will find in paragraph 4, my lord. Paragraph 4, my lord. Examples has been given that in our case, my lord, your lordship is aware that Pasak's case of 1970s, where it has been held that since no appeal lies, it will be a revision. Paragraph 4, my lord. Next, paragraph 4 starts from the second page. My lord, third page, if your lordship kindly turns to, if it is brought on record by a landlord that the tenant did not pay rent in discharge of his obligation, etc., my lord, then lordship will straightway go to the first, second, third, fourth, fifth, sixth line, my lord. Normally, appeal is a continuation of suit, but the same does not apply to a revision petition. But under aforesaid special circumstances, when the trial court judgments and decrees of eviction are considered in a revision petition under section 115 of the Civil Procedure Code, the revision appears more like an appeal than an ordinary revision against an interlocutory order. In the case of so-and-so, a division bench of this court has already held that grounds of default and a bona fide requirement in an eviction suit under section 5 of the Assam Arbitration and Control Act involve jurisdictional facts, and so the High Court is required to go into the correctness of such findings of facts. These being the position in a revision petition filed under section 115 of the Code of Civil Procedure, arising from a proceeding under Assam Arbitration and Control Act, the nature of revision petition resembles that of an appeal. So it is an appeal, my lord, in a sense, only because of section 8, which gives finality to the judgment passed by the First Appellate Court, that we have to file a revision. But otherwise, my lord, the entire judgment is open to the Honorable High Court for scrutiny. So that being the position, my humble submission will be that this Honorable Court is not, my lord, powerless to invoke either section 151 or in terms of section 141, the provisions of Order 9, Rule 9 to, my lord, consider the application and restore the civil division to file.
Okay. Yeah.
Yeah. My lord, it peruse order dated 10/4/2023. By that said order, civil division petition was dismissed for not taking steps about 7 years and for non-prosecution. So that was not dismissed for default. So the submission made by Landlord-tenant is not applicable in the present case. Order dated 10/4/2023, cumulative will find at page 30 of their petition. No, yeah, civil division petition. Page number 18 of their petition. MP 67 of 2024.
Yes. Order dated?
Order dated, my lord, that is at page 18, 10/4/2023.
Yes.
The present revision petition is directed against a decree of rejectment dated 9/5/2011. Passed by the landlord municipal Bogaigaon and order dated 1/7/2014, passed by the landlord civil judge Bogaigaon, upholding the order of the landlord municipal Bogaigaon. The matter was admitted for hearing on 5/11/2014. Thereafter, when the matter was listed on 31/2015, this court directed the London Council to take rectificatory steps by 2/2/2015. Very clearly, there is the order of this honorable court. In terms of office note dated 28/1/2015, no such rectification has been done till date. The office note dated 28/1/2015 reflects that notice to the respondent number 1 could not be issued due to deficient postal stamp. Thereafter, the Lojima court order is order dated 27/5/2016 directed the petitioner to take steps for issuance of notice upon respondent number 2, 3, 4, 5, 6. However, till date, such steps has also not been taken. None appears for the petitioner when the matter was called. Accordingly, the present revision petition extend dismiss for non-prosecution and for want of steps. So I have raised my objection that they have filed the application under Order 9, Rule 9. And you will also find that they have filed the application only under Order 9, Rule 9, not related to Section 151 of the CPC. Their application by law.
No, maybe where misquoting or non-quoting, whether it will have any consequence.
So I am not on that ground. My submission, my Landlord-tenant has submitted that Section 141. Section 141 relating to miscellaneous proceeding. There is no doubt that the procedure laid down in the suit will be followed in the miscellaneous also. So that is a different thing. So in view of that Section 141, application under Order 9 is a mandatory rule. But whether under Order 9, Rule 9 is mandatory rule because it reflects in the case of penalty. But before that, my lord, I would like to submit, my lord, there is also the decision of Supreme Court, whether the petitioner has come before this honorable court with clearness, whether he has suppressed the material facts of the case, whether he has played a fraud with the court and upon the opposite party. And if he did so, there's a decision of the Supreme Court that the petition is liable to be dismissed for action without adjudicating the case. What happens, my lord? He has made false and misleading statement that is on the record. I am taking your lordship at page 7. My lord, come at page 7 of their application. In paragraph 4, my lord.
Yes.
In paragraph 4, they have stated that the matter was listed on 10/4/2023 in the daily cause list under orders column as item number 16. Prior to 10/4/2023, the matter was last listed on 21/2015. That is also a wrong statement because order sheet speaks, my lord, that thereafter on 27/5/2016, case was listed before Lojima court. They have suppressed this fact from this honorable court. Next, my lord, and only on 10/4/2023, the matter was first listed after engaging Mr. S.S. Sharma, senior advocate in the start case. That is also false, my lord. Senior advocate S.S. Sharma was engaged on 23/5/2023. The case was dismissed on 10/4/2023. Your Lordship may kindly peruse the wakalatnama of Mr. S.S. Sharma filed by them, junior has filed, my lord. That is on the record, my lord. I have also flagged market, my lord. This wakalatnama was filed on 23/5/23 after dismissal of. But what they are stating that only on 10/4/2023 the matter was first listed after engaging Mr. S.S. Sharma. They had taken the plea since his name was not shown in the cause list. They were not aware. But wakalatnama will show, my lord, Mr. S.S. Sharma engaged on 23/5/23. That is more serious, my lord, very serious, my lord. And if that is taken by your lordships, my lord, there is also Supreme Court, my lord, that if a cause supported by affidavit is made, the Supreme Court has confirmed one judgment where cost of rupees 10 lakh was imposed. Here the same happened, my lord, at page 9. Your lordship may come at page 9 of their application, paragraph 7, my lord. Stated that the applicant stated that it was only when the applicant petitioner was about to take necessary steps for substitution of legal heirs of respondent number 1 on account of his death. I am before your lordship. They have stated that I have expired. Since I have expired, they were taking the steps. That is, my lord, false statement, misleading statement supported by the affidavit, my lord. Whether all these grounds, my lord, their petition can be considered either on the merit or on other ground when they did not come before this honorable court with clean hands, misrepresented. And my lord, I am listening the decision of the Supreme Court, my lord. How many they have come misleading, making the misleading statement before the court, my lord? My lord. 2021 Supreme Court, my lord, I am reading the relevant para.
2000?
My lord. What? Page number, sorry. My lord, that is written one judgment, 2021 Supreme Court.
Okay.
Page number 804, which is there, my lord. From this judgment, my lord, I am reading para 12, my lord. It is well settled that the jurisdiction exercised by the High Court under Article 226 of the Constitution of India is extraordinary, equitable, and discretionary. It is imperative that the petitioner approaching the Reed Court must come with clean hands, put forward all facts before the court without concealing or suppressing anything. A litigant is bound to state all facts which are relevant to the litigation. If he withhold some vital or relevant materials in order to gain advantage over the other side, then he will be guilty of playing fraud with the court as well as with the opposite party, which cannot be countenanced. This court, paragraph 13, this court in the Prestige Light Limited, State of Bank of India, so has held that a prerogative remedy is not available as a matter of course. In exercising extraordinary power, a Reed court would indeed bear in mind the conduct of the party which is invoking such jurisdiction. If the applicant does not disclose full facts, suppress relevant materials, or is otherwise guilty of misleading the court may dismiss the action without adjudicating the matter. Here, my lord, so much false statement made by them. They have said that I have expired. So when they were taking steps for substitution of legal heirs, then they came to know about dismissal of the case. Next, they have stated that Mr. S.S. Sharma was engaged before dismissal of this case. Wakalatnama so no, he has been engaged after dismissal of the case on 23/5/2023. That is on record, my lord. Your lordship may kindly peruse the record. Next, my lord, I am citing another decision of the Supreme Court. That is 2016 3 Supreme Court cases, page 17, my lord.
Yes.
So, my lord, I am concerned with the paragraph 27, but I am not reading all the paragraph. I am taking your lordship directly at page 76 of the judgment and reading last line, my lord. 76, my lord, of the decision of the Supreme Court, 2016 3 SCC, my lord.
Yes.
Here, my lord, last line, the Supreme Court says, the fact of the matter is that a false or misleading statement was made before this court, and that by itself is enough to invite an adverse reaction. And here, that case, my lord, came relating to one case that was also in para 1 of the judgment. I am reading only one paragraph, para 1, my lord. The only question for our consideration is whether the High Court was correct in imposing cost of rupees 10 lakhs on the petitioner for filing a false or misleading affidavit in this court. In our opinion, the imposition of cost, although somewhere steep, was fully justified, given that the High Court has held the contact of the petitioner was aborted improperly, was accommodated, and so on. So there they have made a false statement. So the High Court has imposed cost of which was conferred by the Honorable Supreme Court. The same thing is happened, my lord. Not to speak of the mentality of the application, merit, when they have not come, on what ground, my lord, this petition can be restored. A restoration is not there, not dispute for not taking steps. There is section 151, your lordship knows, there is a decision of the Supreme Court reported in the 2005 SC 242. Your lordship knows, I have not brought, but I remember, so I have noted down, my lord. There, Supreme Court held, inherent power cannot be exercised at so as to nullify provision of court. So that cannot be exercised. When there is a provision, I have earlier argued that Order 47 may be applicable here in this case. They may come under Order 47 for review of the order. That is because that was dismissed for not taking a step, not for restoration, and not for default. If the case has been dismissed for default, matter would have been different. For not taking a step, then the proper recourse application is to come under Order 47 Rule 4. Not only on this fact. Their first application they have filed under Order 41 Rule 17 for readmission of the appeal, which is withdrawn by them. That application was also barred by time. They have filed that application. This was dismissed on 10/4/2023, and they have filed that application on 23/5/2003. So there was also a delay of 23 days. They have not contained. Even after granting the permission, court has not given them liberty or not controlled the delay. They have filed this project application, which is also barred by 1 year and 3 months, my lord. There is no application for condition of delay. But I am not going to the merit. If your lordship consider all aspects of the matter, the revision petition is not at this restoration application is not at all maintainable. And when they have not come, my lord, how this court can allow, my lord? Whether the court can allow, because the respondent number has expired. So they wanted to substitute. So they are entitled to a relief. My lord, that is not the mandate of the law, my lord. That submission, my lord, on this ground, their petition is liable to dismissal. Even Supreme Court did not decide their case on merit. No, but you did not come before the court. You have played a fraud. That is a big fraud, my lord. I have expired, my lord. But S.S. Sharma has engaged before, so it was engaged. Everything is on record, my lord. The matter was listed again before the Lojima. They have said no.
Okay.
That is
Yes, Mr. Mazumdar, any reply?
Yes, ma'am. My first response will be, the lordship may kindly have a look at the provisions of Order 9, Rule 2.
Yes.
It says, my lord, dismissal of suit where summons not served in consequence of plaintiff's failure to pay costs, where on the day so fixed it is found that the summons has not been served upon the defendant in consequence of the failure of the plaintiff to pay the court fee or postal charges, if any, chargeable for such service, or failure to present copies of the plate as required under by Rule 9 of Order 7, the court may make an order that this would be dismissed. Then there is a proviso, my lord, provided that no such order shall be made if, notwithstanding such failure, the defendant attends in person or by agent when he is allowed to appear by the agent on the day fixed for him to appear and answer. Well, here is a case where my learned friend is appearing for the respondent number 1, who is the landlord. The day on which the case was, revision petition was dismissed on the ground, the steps were not taken for respondent number 2 to 6. They are all legal heirs of the tenant. How can the legal heir of landlord can take a plea that says steps were not taken? It is another thing the court has passed an order. He is the only respondent, my lord. Lord, will kindly have a look at the revision petition. There is only one main respondent. Others are pro forma respondents. My learned friend is trying to take advantage of an order which was passed for not taking steps on respondent number 2 to 6, who are legal heirs of the tenant. They were pro forma. That is why, my lord, probably they did not appear. Some of them are not residing here. And my lord, a respondent who says that CPC is not applicable, provisions of Civil Procedure Code is not applicable because it is a revision petition, neither a suit nor an appeal. How could this order be supported then? The suit is mentioned here in Order 922 because the dismissal for not taking steps for respondent number 2 to 6 is in terms of Order 922. Then my learned friend has to say that that order is wrong, passed by the Honorable Court earlier, because they have appeared. Main respondent has already appeared by the time the suit was dismissed for default. The revision petition was dismissed for default. How could it be dismissed, my lord? Proviso says that no such order shall be made if, notwithstanding such failure, defendant attends. Defendant, in this case, if the defendant is to be treated to be respondent, the respondent had already appeared. There was no question of dismissal on the ground of failure to take steps for service of notice on that too on the, my lord, tenant's legal heirs. A submission is made that CPC is not applicable, provisions of civil procedure is not applicable in a revision petition because in Order 9, Rule 9, revision is not mentioned. The same argument will have to be applied here also. If suit is mentioned here, how would it be dismissed then? It could not have been dismissed. Revision word is not mentioned in Order 9, Rule 2 because the present dismissal, if any, for not taking steps for service of notice on respondent number 2 to 6 are concerned, then it is in terms of Order 9, Rule 2. Where the revisions are not mentioned here, only suit is mentioned, then it will amount to, my lord, an action, approbate and reprobate at the same time. And otherwise, my lord, the main respondent, who is the landlord, had already entered appearance, and your lordship will kindly see from the order, my lord. From the order, lordship will find the name of my learned friend is page 18 of the IE, my lord, MC, Miss Case 67.
There is no dispute. I have appeared.
You are appearing for the landlord now. You are taking a plea that notice was not served on respondent who were pro forma respondent and legal heirs of the tenant. For that, I should get the benefit.
My lord, with respect.
Let me complete. You will get your chance. You are trying to take advantage of a failure on our part for not serving notice on my legal heirs. You are already there. My learned friend's name is there. He was already appearing for the main respondent landlord. So to that extent, the order is bad. And for that, my lord, the application for restoration is to be filed under Order 9, Rule 4. I'll pray before lordship that lordship will invoke Order 9, Rule 4 to restore it so far as that part of the order is concerned, which says that, my lord, plaintiff may bring a fresh suit or court may restore the suit to file on Order 9, Rule 2, Rule 4, my lord, where the suit is dismissed under Rule 2 or
Rule 3, the plaintiff may, subject to the law of limitation, bring a fresh suit, or he may apply for an order to set the dismissal aside. And if he satisfies the court that there was sufficient cause for such failure, as is referred to in Rule 2, or his non-appearance, as the case may be, the court shall make an order setting aside the dismissal and shall appoint a day for proceeding with the suit. This is one aspect, my lord. The other aspect is, my lord, my learned friend is taking the plea that there was some misrepresentation. My lord, will kindly have a look at page 15 of the IE, my lord, MC.
Page number?
Page 15. It's a cause list, my lord, where the names of the counsel are appearing.
Yes.
My lord, the senior counsel, all of us are aware at the bar that he died. Then his junior PCN also died. Then second one is he has left profession here and he has gone to Barak Valley, and there he's also unwell, my lord. All of us are aware. And so far as P.K. Debra is concerned, I do not know, my lord, he's also not here. So in such circumstances, it's not a case, my lord, where the practicing lawyer who is practicing here has defaulted. Two of them have died. One has left and he has gone to Barak Valley. And first one, P.K. Debra, he is not in practice. No one has seen him for years. An objection has been taken that from where, well, paragraph 6, Lord, will kindly see the kind of objection there is. From whom NOC has been taken. When a person has died, who will give the NOC? And when if a objection is raised bona fide, you will consider. Here is a case, the restoration petition was filed earlier. It had to be withdrawn because my learned friend raised an objection that you have filed a petition under Order 41, Rule 19, readmission, provision for readmission, which is to be applied in an appeal. On that objection, my learned friend withdrew the earlier application for restoration. And in the meantime, they are proceeding with the execution. Lord, will kindly have a look at the order. Because they are possibly thinking that this revision petition, they do not have any merit. So they want to execute the decree of eviction by keeping this restoration petition pending as long as possible. Here lies, my lord, the absence of bona fide on the part of the landlord. I know earlier, my learned friend, my lord, in a case where revision petition is dismissed, it is a general practice followed here that a restoration petition is filed, and if good cause is shown, it is restored. Objection is being raised that provision of Order 9, Rule 9 is not applicable. There are judgments, my lord, 3 judgments I have shown. And in the judgment which I have shown by Honorable Justice, then Justice N. Chaudhary, there, my lord, the objection was raised that the provisions of substitution under Order 22 is not applicable in a revision. Then the Honorable Court said, no, it's an appeal. And that is why it is applicable. And second time now we have filed a second petition. Now again some objections are being raised so that the execution can take place, and thereafter they will say that the decree has been executed. And we want that this Honorable Court will take a decision on merit of the revision petition and nothing else, my lord. After hearing the revision petition, if your lordship finds that we have not been able to, my lord, say that the finding of the learned court below is incorrect, the lordship will dismiss our petition. So let there be decision on merit, my lord, so that the petitioner goes with a feeling that his petition was heard on merit and ultimately court has taken a decision.
Madam, in reply, madam, I shall not take much time, madam, because your lordship has heard me and I have made submission. Here, my question arises, madam. They are shifting their burden on me. They have filed the revision petition. I have not filed. They have made the pro forma dependent a party. So under the law, what is the duty to take a stage for issuance of the notice on the pro forma respondent also? Whether they are the legal heirs of the deceased father or not, that is not the subject matter. They have made the pro forma dependent a party, not there. Also in the revision petition, they have made them respondent also. So their duty to take the steps. If they don't want to take a step, they should have made the submission before the court that their name should be a step up. That was also not made. They have not taken the steps. Beyond that, so far I know, he has perhaps expired in the year 2021. They have not stated the date of that. But the order which was passed by this Honorable Court for taking a step was long before. That was on 27/5/2016, Lok Sabha court has been directed. Before that, this court has also directed. So during this period, about 6-7, what happens? All the juniors are there, not whether it is the duty of the court to call them. Why you have not taken the step? It is my duty. I have come. Court has passed the order, admitted, directed me to take the steps strictly, your lordship, by 2/2/2015. In spite of that, I have not done. Now they have shifted the burden on me, showing the decision of Jammu and Kashmir. Whether they have shown any decision. So far, my submission, my submission, that the revision petition is a kind of appeal. My lord, what is this, my lord? Revision lie under section 115, and that appeal lie under order 41. And yes, no, Supreme Court understood. That was quoted by the in our judgment. That's only that in the form has been prescribed. They have a form because in the order 41, only ground has been taken, not the facts narrated. I have to come the grounds showing what is the irregularity and illegality. In revision petition, I can state facts as I also can take the ground. So that was there that the form of appeal or form of revision petition may be same. So that does not mean a revision is an appeal. My lord, I have heard first understand. So my lord, I don't make anything, my lord.
Okay, okay.
My solution, my lord, that I am suffering, my lord. 2002, I have filed a suit, my lord. 2025 is happening. They are preventing me from enjoying the fruit of the decree, my lord. What is this, my lord? But therefore, I should suffer. That's all.
My lordship will pass an order protecting us till the revision petition is decided, because before the executive court, we filed an application for stay. Now, because of the pendency of this restoration petition, they have
No,
opposed.
I am yet to take a decision of whether I will allow this. petition or not.
Absolutely, if your lordship passes an order of restoration, my lord,
Okay, okay.
in that event, I am saying,
Definitely.
because my lord, London Court below has passed an order, accordingly, this court, in the letter and spirit of order number so passed by the Registrar General of Guwahati High Court, hereby directs the decree holder to take necessary steps for execution of writ in the respect of the decree passed by the trial court. Your lordship is aware, my lord, because of the judgment.
Yes, there is a direction of
Direction
court
Supreme
to
Court, my lord,
initiate
yes.
disciplinary proceeding against the presiding judges.
But that's what I'm saying, my lord. Lordship will consider that let there be a decision on merit of the revision petition. That is our.
Lord Mr. D. Majumdar, learned counsel for the petitioner, and Mr. Sunsetfield, learned counsel for the respondent. Argument concluded, order reserved.
My oblige, your lordship.
32.
This I is for continuation of delay of about 4 days in filing the arbitration appeal.
Service completed?
Service completed. Initially, respondent number 1, my lord, the service was completed, also appeared in the court, my lord. And so far as 2 and 3 are concerned, on the last occasion, 4, 6, my lord, on my prayer, my lord, their names have been struck off. So that way, my lord, the service is complete.
Okay, it's S2D.
The peculiar nature of this case, my lord, what happened, my lord? Initially, the respondent, my lord, the respondent was the, my lord, contractor under the NHIDCL. NHIDCL has terminated the, my lord, contract. They have filed an application under section 9 of the Arbitration and Conciliation Act before the civil judge, senior division number 2, Kamrup. And an ex parte order was, my lord, passed, whereby my lord, the encashment of the bank guarantee that was given, that had been, my lord, injuncted. Now, my lord, they have preferred and, my lord, writ petition before this court, challenging the termination order, termination of the contract. now this court having found that both the parties have agreed for the jurisdiction, territorial jurisdiction in the court at Delhi, the writ petition was dismissed. And thereafter, they have filed an application before the learned civil judge senior division that they want to withdraw this particular petition. That was on 30/4/2025.
But Mr. Sokia, you see, the name of Ms. S to D is reflected against the respondent number 1.
Lordship.
Today, she is not present.
On the last occasion, she was also not present. We had informed her, my lord. Because why I am saying the background of the case. Now they have filed an application before the trial court for withdrawal of the petition under Section 9 of the Arbitration Act. The court has closed, my lord, but no order has been passed till today. So therefore, the interim order, my lord, continues. Had that, my lord, petition been some order would have been passed on that petition, my lord, the present appeal would have been, my lord, infructuous. So, my lord, they are not appearing before this court only
No,
for.
that's all right,
Lordship.
but spite of reflection of her name in the court list.
Lordship.
Can we release the matter on Monday?
So in that case, my lord, let's be on, my lord, Friday next, my lord.
Friday.
Friday next.
No, you were submitting that there is urgency.
Urgency, my lord, for the next week, I'll be out of station, my lord. That's my personal difficulty.
No, anyone can appear on your behalf. No, if there is no urgency, then Friday or
No,
no
my
problem.
lord, problem is that, my lord, I have been, my lord, engaged by the, my lord, company, my lord, and to assist me, my counsel has been, my lord, engaged. So, my lord, my appearance should be required in this case. My lord.
Okay, that's all right. Then Friday.
Friday on
Friday.
20th.
Heard Mr. P.J. Soikia, learned senior counsel assisted by M. Nirola, learned counsel for the applicant. None appears for the respondent number 1, though the name of one is S to D is reflected in the cost list. Place the matter on Friday. In the event of subsequent non-representation of the respondent number 1, appropriate order shall follow.
Right. Oblige me.
33. Service on the sole respondent is awaited, lordship. Service upon the sole respondent is awaited, lordship. Neither AD card has returned, lordship.
Okay. Heard Mr. Arpokon, learned counsel for the petitioner. Occasional dated 10/6/2025 indicates that neither AD card nor unserved notice returned. Unserved notice in respect of the sole respondent received by the section payback. List the matter after 2 weeks, awaiting
No.
service report upon the respondent, sole respondent.
So I'm praying for a date because there is no interim order, lordship. Can be date.
Take a date from him.
Vacation on 18 July.
Lordship.
34.
This matter will take time. It will be taken on 20th.
20th.
My lord.
Tuesday.
I am appearing for the respondent 117 here. Thank you.
No, neither.
19, 20 I have some difficulty.
18, but
Then suggest the date.
16, 17, otherwise or 23.
20, no,
Okay.
23 I will not be available, my lord.
25
On 20th, I will leave for outside.
24,
In 20th, I have taken the consent of my lord.
20th,
Mr.
we
Deka.
didn't know about his inconvenience.
process file going sir. No,
মই তো 20 তারিখ গুছি যাম না
16, 17 no.
16, 17 month.
No,
তেওঁৰ
before,
অসুবিধা আছে
no, before the vacation, there may be a notification from the registry that only the motion matters will be taken up.
Right.
So
18th will not be there, my lord.
it is better not to fix immediately before vacation.
My lord.
7
After the vacation then.
কতটা
It is otherwise come for orders one. It'll otherwise come for. So I think even if it's declared as motion day, orders matters should be listed. Though I'm not sure.
There is urgency matter. The respondents are siphoning of the fund of the.
No, that's all right. I am ready to hear the matter, but the inconvenience is on your part.
On my part, but this matter will take time, Lordship, not more than, not less than 1.5 hours. If it is.
When?
Facts are lengthy.
Suggest the date.
I have suggested 20th, Lordship, because
20th. 20th, he has some inconvenience.
His role is otherwise minimal.
Well, I am the
practically no role.
I have been made the respondent 1 and 2 here. Though my role is minimum, I don't know why they have made me main party here.
Okay.
26 July, 26 June. That's
26.
26. Okay.
26 June.
Okay.
I will not be able to, I live on 20th. I am.
16, 17, no.
দিন পারি কিন্তু ইয়ার বরুণর অসুবিধা পাৰিবা এদিন
time level.
16 and 17, already a lot of cases have been fixed. So this matter may not reach on that day also. Then let it be after vacation.
Well, problem is this, Lordship, the matter is fixed in the trial court on 30th. So before that, if the injunction matter is, the suit will become infructuous, Lordship.
What to do then?
17 তারিখ
You settle the matter amongst yourselves and apprise this court master who will accordingly fix the date. Next item.
35.
In view of the earlier order, my lord, we have filed a petition for.
Pardon?
In view of the earlier order, my lord, we have filed a petition for amending the main memo of appeal, my lord.
Acha.
1634. Miss case.
Okay.
By this miss case, my lord, we have filed certain amendments.
Acha, this memo of appeal.
Yes, yes.
Okay.
First, substantial
Heard
question.
Mr. D.K. Das, learned counsel for the applicant, and Mr. Yersum, learned counsel for the respondent. This interlocutory application under Order 6, Rule 17, read with Section 151 of the Code of Civil Procedure is prepared by the applicant for amendment of the memo of appeal in RERA appeal number 04 of 2025. Where is the mistake?
My lord, here, my lord, the substantial questions of law are, my lord, we annex after certificate, my lord. We have annexed the certificate, substantial question of law, that is after, my lord, certificate. So.
Okay.
That should be before certificate, my lord. In view of section, subsection 3 of.
Yes, yes. The learned counsel for the petitioner, no, for the applicant submits that in the memo of appeal, he has enclosed he has suggested the substantial question of law after the certificate being enclosed in the memo of appeal.
Yes.
But the same ought to have been before the certificate. Then as such, he submits that he may be allowed to make necessary correction and to file amended memo of appeal. Mr. Sum submits that he has no objection. Taking note of the submission of learned counsel for both the parties, this interlocutory application is hence allowed. Mr. Das, learned counsel for the applicant shall file amended memo of appeal within 1 week from today.
But tomorrow we'll file.
Tomorrow.
We are ready to.
Tomorrow is holiday.
Oh, next week.
Next.
Right.
36.
in one.
May please Lordship, I am appearing on behalf of respondent number 1, and I has been filed by me for early hearing, Lordship.
Have you served a copy upon the respondents?
Yes, sir. Already been served upon the appellant.
Okay, if you are for the respondent.
I am the respondent number 1,
Okay.
and I am the plaintiff in the original title suit.
Is there any objection on the part of the appellant?
Appellant, they do not appear today.
Not
Lordship.
appear. Who is the counsel?
Some Sodori, Your Honor. Lordship, I didn't meet him.
You meet him?
No,
No.
that's it.
No, we may allow this application, but later on the other side will come and raise objection that without hearing him, we have fixed the date. Let notice go then. Heard, Mr.
G. Kakoti.
G. Kakoti, learned counsel for the applicant. This application is preferred by the applicant. This interlocutory application is prepared by the applicant for early hearing of RSN number 17P of 2024. Issue notice to the respondent. By registered post with AD and also by usual process within a week from today, list the matter. After 2 weeks then?
Lordship.
If you meet the counsel, you can inform him.
Lordship.
37.
May it please your lordship. Your lordship, this matter has come up for the first time. There has been a delay of 9 days in filing the appeal.
9 days delay. Okay. After 4 weeks?
Oblige your lordship.
39.
In this case, my lord, what has happened actually, my lord, decree was there, my lord. To kindly peruse your lordship, I am straightway going to the decree, my lord, against the execution proceeding, my lord. I have come here before this honorable court. It was dismissed for default, my lord. Decree was for specific performance of contract, and that is page 65. Kindly peruse your lordship.
So both the parties are ready for hearing.
Let it be
Yes,
after
sir.
vacation, my lord.
No. Your lordships, I'm ready for hearing. In fact, by this order, execution was stalled. Problem is hearing, your lordship. Execution petition was dismissed for default. And learned executing court was pleased to restore the execution petitions against which the revision application was filed. So, your lordships, if it is restored and execution petition can be filed many times, your lordships. So, if it is restored, what problem he is having? And because of this application, your lordships, it is restored. Execution against the degree can be filed many times, your lordship, even if it is dismissed for defaults. Now, your honor, in this case, it is restored, against which he come before your lordships. And your lordship, the reason which is cited, the reason on the which your lordship, it is a execution petition will restore, your lordship. It is genuine reason, your lordship. What happened in this case, your lordships? Well, taking the dates, your lordship, there is a court diary. Nowadays, your lordship, in the computer, there is a CIC's update, your lordships. And in the, your lordship, in the execution petition, in the case, your lordship, the date was given. What happened in this case, your lordship? The date which we collected from the code diary, as well as from computer, your lordships, it is 14/2. Whereas in actual, in case, your lordships, in the case, it was for 12. December, your lordship. So, your lordship, because we collected the date 14/2 from the diary and CIS, and we don't know what date is given in the case, your lordships. So, in between this date, 3 date has already been gone, and therefore to dismiss for default. So there is no default from our side, your lordships. And immediately when we come to know the dismissal, your lordship, we file an application. Please, your lordship, order may be used. Order may be used. Whether it can be interfered with.
No, he has the right to begin.
Yes, my lord. According to me, my lord, there are two my lord, decree, my lord, lordship, page 65. Very short, my lord, one page. Alternative decrees were there, my lord. Page 65. A decree for specific performance of contract, height agreement, sale deed number 23/6/11. When the plaintiff accepted the offer of the defendant for purchasing the suit land as described in this schedule below by directing the defendant to execute and register the sale deed in the name of plaintiff by transferring the suit land by way of absolute sale on receipt of the balance consideration amount, and defendant may further be directed to hand over the actual physical possession of the suit land to the plaintiff by removing the man so and so. Alternatively, a decree for realization of an amount of rupees 3 lakhs so paid by the plaintiff to the defendant as an advance against the suit land with interest 12% per annum from the date of receipt of the said amount till date of payment of the said amount if competent authority is prevented by existing rules to accord permission of sale or registration of sale deed. Here, my lord, what has happened, my lord, I wanted to pay back that amount 3 lakhs because, my lord, the permission cannot be given, my lord, to him because it is a tribal wetland. That is why, my lord, I submitted my application before the my lord, court. Here I specifically mentioned that.
No, you show me the impugn order.
Yes, my lord. Impugn order, my lord, that is
97.
99.
96. Page number?
Page 99, my lord.
96.
96 only, sir.
199.
99. And in the meantime, he also default, they did not appear and dismissed for default.
Yes, the court has observed that sufficient cause has been shown.
Yes.
For our non-appearance. So what wrong with the order?
Because, my lord, even otherwise also, my lord, I wanted to pay back the amount along with the, my lord, 12% interest. That's why I submitted application also, my lord, before the landed court below. Even after, if it is your lordship allow also, then, my lord, as it is a land of, my lord, tribal belts, permission cannot be obtained. And thereafter.
No, we cannot in this petition deal with that issue.
Yes, my lord.
Here you are against the order for restoration.
Restoration, my lord.
So you show me what wrong with the order.
Yes, my lord. Page, my lord, 74. Page 74, order 6, my lord.
No, impugn order is page number
99, your lord.
99. But prior to that, he did not appear, my lord, on the on that 74 page, my lord.
No. You show me from here how this impugn order is illegal or arbitrary.
But according to me, my lord, it is mentioned, my lord. According to me, my lord, they were, my lord, intentionally avoided because, my lord, they cannot be able to, my lord, get this, my lord, they cannot be able to, my lord, deposit the amount, my lord, because my lord, for the.
No, suit has already been decreed.
Yes, my lord, decreed, my lord.
Then?
But his prayer was to deposit the rest of the amount for registration, and my prayer was, my lord, to pay back the amount, my lord, along with the interest, my lord. During this process, it was dismissed for default, my lord. Because of the ground.
After sufficient
tribal
cause
ban.
was shown, then thereafter the court has learned court has restored the same.
Restored the same, my lord.
Then
That is only matter against the same matter I have filed this.
No, that's all right.
yes,
Show
sir.
me how this impugn order is illegal or arbitrary. You are not prepared,
Yes,
perhaps.
my lord.
Huh?
After vacation, my lord.
No, no, no.
Or Friday also, my lord.
Your lordship, on Monday or Tuesday, your lordship, because
Monday not possible.
Tuesday, your lordship.
Sorry?
Otherwise, your lordship, your lordships, from mere reading of this order, your lordship.
No, that's all right, but he has to be given an
Yes,
opportunity.
yes, your lordship. So Monday or Tuesday, your lordship.
Not Monday,
Tuesday.
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 Okay. That's
17.
agreed by learned advocates of both the parties. This is the wisdom.
Item from production list to be spoken to, RSA 86 of 2025.
Mr. Bose, you have suggested two substantial question of law. The last one is whether the learned court below erred in law in dictating the suit of the plaintiff without considering the provision of Order 7, Rule 3, which requires when suit of immovable property, the plain shall contain a description of the property sufficient to identify it.
Yes.
Now come to the schedule of the plain.
There are two schedule has been mentioned, man. Two schedule. One is 2 katha 19 lesa out of 1 bigha 18 lesa covered by so and so. Another plot of measuring 2 katha 19 lesa 1 bigha 18 lesa. And in the pleadings, they have said that from this schedule, part of the property I have been disposed. They have been dispossessed from part of the suit property. So from which part? Kindly see the statement. That is why I am saying that schedule has not been properly described.
No, you tell me no. There is averment in the plain that they have encroached the entire land.
No, there is no averment. That is why I am showing, my lord.
Yes.
Paragraph 4. There is no averment. It is rather averment that that main defendant without right title, interest and possession over the scheduled land after hearing sold out to the plaintiff. The main defendant taking advantage that plaintiff as well as their vendor are residing at a distant place with ill motive and design encroach in some portion of the suit land by demolishing the boundary fencing and constructed temporary shed thereon on or about so and so, and as such plaintiff approached the pro forma defendant for cost survey and demarcate the boundary of the suit land. Lordship got it? They after purchase they have said that no, some portion have been encroached by us. So first you demarcate, then demarcate the land. So and so demarcation of the boundary of schedule so and same has been sent to CO Shodor Revenue Circle, but for ulterior reason the process has not been completed.
No, you come to the letter. Yes. Subsequent portion.
Yes, the main defendant with a view to grab the entire scheduled land threatened the principals to dispossess from the scheduled land. Threatened to dispossess, not said that we have been dispossessed. We have been part of the schedule has been dispossessed. Now they are.
Then come to the later part.
Yes. Grab the entire scheduled land, threatened the plaintiff to dispossess from the scheduled land and also denied the title of the plaintiff thereon and illegally occupied
The whole
the
scheduled land.
whole scheduled land.
Then
it is there.
Is it not identifiable?
No, it is, my lord, there only language is that they are try to grab this land.
No. Occupy the entire land.
No.
Scheduled land.
The main defendant with a view to grab, the entire scheduled land,
threatened the plaintiff to dispossess from the scheduled land and also denied the title of the plaintiff thereof, illegally occupied the whole
And
whole
illegally occupied the whole scheduled
scheduled land. The plaintiff protested, this is only abutment that we have, and we have wholly occupied the scheduled land. But in the prayer also, part of the scheduled land, prayer also is there. The demarcation is, and why demarcation, my lord?
Where it is mentioned pair person.
Prayer, page 10. Decree for delivery of khas possession of scheduled land of the plaintiff by demolishing any structure, construction, and removing the belonging of the main defendant therefrom by demarcating the boundary. Why said by demarcating boundary? Because in the western part, our land. We are in western part. This is our own land, not with respect to this suit land. And it is mentioned in the schedule also in western side, kindly see. Oh, eastern part, Vipul Goswami, east part. East part is our land. And west, they have shown the land of the plaintiff. That is this part of the scheduled land. Kindly see the page 11. Page 11, schedule. North, river, south, Sarkari road, east, Vipul Goswami, schedule, first A schedule. Vipul Goswami, here in the defendant. West, Srimati Anjali Soikia, Mahanta, plaintiff number 2.
So whether NSS plea was taken before the trial court and also before the
Yes,
first
yes.
appellate court?
Yes, yes.
When? Where?
Because issue also came to that
Where?
aspect.
Where?
Issue number 4. Issue was also came. Kindly see the issue, my lord. Page 43, issue number 4. Whether the defendant encroached some portion of the suit land, lordship got it, by demolishing the boundary fence and constructed house thereon, as is alleged in the plaint. So issue was also framed, and this issue, kindly see issue number 4. No discussion by the trial court. Then I will come to the appellate court.
No, may not be, but the
Page 52.
appellate court has discussed it.
No, in this issue, there is no discussion. Issue number 4, page 80, kindly see, appellate court. Page 80. Lordship got it?
Issue number 4.
4. This issue related
Page
to the
21.
page 21 of the trial court. That is trial.
No, appellate court order.
Appellate court, page 80. Yes, in our internal page 20. This issue relates to alleged dispossession of the plaintiff by the defendant from the portion of the suit land and the plaintiff and entitlement to the relief paid for. The plaintiff in their plaint and evidence have claimed that the main defendant without any right title interest and possession over the scheduled land after hearing that the scheduled land had been sold to the plaintiff, taking advantage that plaintiff as well as their vendor resides at a distant place with ill motive and design and goes some portion of the suit land by demolishing the boundary fencing and constructing temporary shed thereon on or about so and so. Thereafter, plaintiff approached the pro forma defendant and they in turn filed a petition before the additional deputy commissioner Nagaon for demarcation of the boundary of the scheduled land on so and so. And although the same has been sent to CO Sadar Revenue Circle, but ulterior reason the process has not been completed. Actually, this is the appropriate process, my lord, under Assam Land Regulation. Only this is a boundary dispute. Admittedly, the defendant are in possession of the suit land, which has this person is not correct, my lord. There is no admission that we are possessing the entire suit land. This part is not in consonance, neither in evidence nor in the written
Have you
statement.
denied it in your written statement?
Yes,
We have denied.
So your written statement.
We have denied all the.
You are taking the adverse position, plea of adverse position. And also you denied the title of the main pro forma defendant. Pro forma defendant.
That is the plea taken in plea taken. Kindly see the written statement at page
No,
28.
while you were taking the plea of adverse position, can it be said that you have not encroached the land?
No, if I am taking the plea of adverse possession, it is the admitted fact that I am admitting the title of other side. If I taking the adverse possession, that means.
But you have denied it. The court has observed it.
No. If I have taken the adverse possession plea, it means that others title has been admitted. Not that possession or.
What document you have exhibited to show that you were in possession of the suit land since 200 years?
My lord, my case is that adjacent land, from schedule I have shown, adjacent land I am residing.
Maybe.
It is my own land.
No,
It is not that they are claiming adjacent land.
No, Mr. Ghosh, you tell me whether from the schedule of the plane,
Yes,
the suit land is not identifiable.
suit land. My lord, my humble submission that suit land is not identifiable because within this patta there are other lands from which I am occupying portion of the land of my independent right. Not the suit land. I am not claiming over the suit land. I am claiming that boundary. It is actually case of boundary.
Sometimes you are taking the adverse possession, and sometimes you are saying that you are not in possession.
No. I am not saying that I am not in possession. I am saying that the entire suit land is not in my possession.
Okay, we will pass the order today.
And so far, second is concerned regarding barred under Assam land regulation.
Oh, we'll see whether that section is applicable here or not.
Oh.